May it please Lordship, with the consent of the other side, I beg to mention item 12 of today's daily list.
My lord, my lord, we have little, my lord, difficult in this matter, my lord, because here, my lord, the issue is of internal inquiry, my lord. If a short date can be fixed, my lord, my only prayer is this. Any date convenient, my lord?
Lordship, application of-
Any date when the land AG will be available.
Lordship, 17th will be little difficult. Or maybe on 30th October.
30th will be very far, yeah. Yes, my lord.
From
The AG is not available, then we cannot do a hearing. 30 sir will be available. No?
17th.
Sir will be available. My lord, if the learned AG is not available, then
30th will be Lordship will do the matter on 30th, Lordship.
Okay.
Will be available.
an attempt will be made, my lord, on that day to dispose of the matter, my lord. That my lord will observe, my lord.
Okay.
Deeply obliged.
May it please your lordship. Your lordship, I beg to mention item number 24.
Item 24.
24, your lordship. Adjournment slip also been filed, lordship. The conducting council is out of station for her medical treatment, your lordship.
The prayer being made by Ms.
You, Sir Gary, lordship, on behalf of S. Sharma.
Delivering on behalf of
S. Sharma,
S. Sharma, Burnett, that we counsel for. No,
Pet-
petitioner.
petitioner, lordship.
Burnett,
Matter may be listed after puja vacation, lordship.
that's adjourned to be listed after the.
Obliged, lordship.
May I please your lordship? Lordship, with the consent from the other side, I beg to mention item number 13 for adjournment.
30.
13, 13.
Sir, your good name?
KK Medhi on behalf of SK Medhi.
TK Mehdi, Burnett, every behalf of SK Burnett. After petition. Fair.
Item number 10 from the daily list, madam. Matter becoming 10. Infectiousness. Regarding pensionary benefit. Already got it.
When do we want?
Withdraw it.
Withdraw. Okay. The T group is Burnett. Accordingly, it's a. Withdraw.
Diplomat.
Items for approval mediation. Number 1.
No, Lordship, we would like to file an affidavit in this matter. So it may be fixed in the admission column.
No sons for reconciliation.
No, Lordship. We'll have to examine this. He has been seeking for arrear salaries for quite some period. So I obtain instruction and file an affidavit in this matter. It may be fixed for admission.
Give me short date.
A.K. Ghosh on behalf of Mr. K. Kumar.
AK.
Ghosh.
Sir.
K. Kumar.
K more.
Senior Standing Counsel PNRD.
Also for
PNRD 1, 3, and 4.
do the matter is listed under the column first. The Burnett that number subset. Purpose to start by the president. And if we fight on it. And that's what I don't know. I can get it. It is according to the law. I can get it. Immediately after reopening.
Obliged, Lordship.
Number 2.
May I please, Lordship?
The matter relates to determination of qualifying service to get a pensionary benefit, Lordship.
So. So purpose will be served by referring the matter to the mediation.
It may be, but my client is bedridden.
Pardon?
My client is bedridden, my lord. He's unable to, Lordship.
Then we will leave the matter for admission hearing
Lordship, after 4 weeks.
after. Anybody for respondent?
Sir, respondent number 5 and 6,
Your name, please.
M. Kalita.
And call it out and it- Number 5 and 6. Do the matter. Certain column. The learned counsel for the fixed subjects that shall be delivered and not monitored. And the search lies for the data for according to provided that after vacation.
Public.
Item 3,
Please, your lordship, this matter pertains to introduction of a pensionary scheme for the employees, retired employees of the Khadi board, my lord, and conversion of their CPF to GPF. So therefore, this will not be resolved by the mediation. This matter will have to be heard by this honorable court.
Pardon, your good name?
S. Sharma Azari.
Sharma, learned counsel. That also heard, sir, what are you for?
I'm PK Murimi.
You are for?
I'm for one. I'm sorry, not one, but four and five.
4 and 5. And you?
And they on behalf of Arthur for respondent number 1 and 3.
One. Do the matter is listed under the copy. It's submitted at the bar, that no purpose of this part. Provided that this is the method for admission hearing after immediately after reopening of the.
Okay.
number 4,
May it please your lordship. My lord, this is a matter pertaining to family pension.
Yes.
The family pension was erroneously granted to my estranged husband's second wife for 1 year after his death. But before I could challenge the same, his second wife also died, madam. So this is why the writ petition has been filed that actually I, being the first wife, was entitled to the family pension, but before I could assert my claim, the person who has been given the family pension by department, she has also died in the meantime, within 1 year of the death of the employee. So if the department is willing to consider that aspect, that from the time of the death of the person receiving the family pension till onwards, then that can be referred back.
Sir, SC High Court will take the decision.
Who?
SC High Court.
SCGFC,
Who is the same?
standing counsel.
Guwahati High Court, Lordship. Lordship.
This is because
The petitioner's husband was a service in district and session judge, Lordship, district and session judge,
in the establishment of the honorable district and session.
session judge, Lordship.
Lakhimpur.
Lordship, Lakhimpur, Lordship. And the pension proposal will come from the establishment of the district and session judge, Lakhimpur, Lordship. Therefore, we are on behalf of the pension department, Lordship. Until and unless the proposal we receive, Lordship, we cannot take any decision, Lordship. They may approach before the establishment of the district and session judge, Lakhimpur, Lordship.
We have approached, that is, we have annexed the representation.
Then,
Judicial Department?
Lordship, we have a standing council in the Guwahati High Court, Lordship.
Yeah.
And Lordship, a panels are there, Lordship. TJ Mohanto, Senior Counsel TJ
Yes,
Mohanto
this
is
case,
also.
Mr. TJ Mohanto.
TJ Mohanto is the
appearing.
Who had received notice?
TJ Mohanto.
Also, Gautam Bushra. I think it should be Mr. D. Bushra. The names are have to be reflected in the cause list. No, the SCGHC is not shown in the cause list, madam, because SCGHC's name is not reflected in the cause list. It can be listed tomorrow again with reflecting the name of the standing council GHC. Then a call can be taken in this matter.
And is that something for?
1 and 2 pension department also, director of pension.
Oh, pension department. Pension department. So Board submitted that the name of standing council of Guwahati High Court is not reflected in the policy. And as such, the measure will be examined to this thing. The name of standing council of Guwahati High Court. There is a good idea of the measure tomorrow, reflecting the name of standing council of Guwahati High Court. If that was.
Item 5.
May I please, your lordship? Lordship, we are ready for this mediation, my lord. It can be sent. It can be sent. my lord.
Or so if it will be apparent. For number,
I am appearing for 4 and 5, my lord.
number 4 and 5, and Mr. Sorting,
1 and 3, Lord.
1 and 3.
Three.
So Solia,
Lordship, I am appearing for 2. Lordship, 2.
2.
Yes.
is submitted at the bar that the matter may be referred to the mediator. Accordingly, it is provided that Bristol is the matter, the mediator, got the High Court petition. And the parties are directed to appear to the mediator on or before.
On fix a date, my lord. Or before my lord, the bond of puja. After puja? After puja, before puja, did you? Before vacation, post side. 25th. 25th of September.
Mediator will file a report. It was
Usually,
report within the
Much.
Six.
Right, please, your lordship. Madam, this matter relates to non-payment of gratuity to the retired employees of Jyoti Chitrabon Film Studio Society, madam. The only society owned by government which, my lord, is dealing with film production, my lord. In fact, this is a covered case, my lord. Previously, this question was gone into, and I have annexed that judgment also within my petition, my lord. First batch of the pensioner, my lord, retired employees have been given the gratuity pursuant to a directions of this honorable court. Lordship will find this judgment in page 63 of my writ petition, my lord. In fact, it was legally examined in detail, and whether they are entitled to gratuity or not. And the government notification was also discussed, the central government notification by which the societies, government societies were brought under the garb of the Payment of Gratuity Act, my lord. Finally, it was decided that the retired employees will be entitled. Accordingly, directions were passed and they have received, my lord. The previous batch of retired employees have, my lord, received the gratuity.
They were also the employee of the society.
The same society, my lord. Jyoti Chitrabon Film Studio Society.
Yes.
Sir, I am for reference number 5 and 6. I have no objection.
Not in-
No. Matter may be referred to mediation.
Light of,
Lordship,
we dispose of the petition
lordship, lordship. In light of the judgment.
of this court.
Lordship. Deeply. Lord.
Item number 7.
Lordship, this matter relates to pensionary benefit as the husband of the petitioner was an employee under Air Force as Chokidar. And your lordship, as per the government provision, the husband of the petitioner was entitled to pensionary benefit at a revised rate. And the respondent authorities had agreed to revise the pensionary benefit on several times, your lordship. But they have not granted the benefit of revised pension, and as such, your lordship, the petitioner was entitled to approach this honorable court.
Who is for the respondent? Okay. You pick the- It's- After some time, conflict is absent.
After some time,
After some-
Item 8.
May I please, your lordship, the matter relates to non-payment of pension, lordship. Now, by order of this court, they have paid the provisional pension. The petitioner is receiving provisional pension, Lordship.
Can you refer the matter, mediation?
Lordship, petitioner has no objection subject to what the department.
But we have raised the objection that this matter is maintainable in cap, my lord.
That I have answered.
We have paid the provisional pension and all others except the because of financial irregularities, my lord. As per the audit report.
Lordship, audit report they have not annexed here, neither have they served a copy upon us.
We are waiting.
Have you filed your affidavit?
Yes, sir, I will file, my lord.
Pleadings are complete, Lordship.
Pleading complete. And let us put the matter for admission hearing.
Lordship.
Heard, miss?
P. Sharma, Lordship.
Internal Learned Counsel for the Vacate that for the respondent. Do the matter is listed under the column submitted in the bar that is by referring the matter to the mediation. And further it is submitted that pleadings have already been completed. Accordingly, it is provided that the matter after admission hearing.
Lordship, kindly a date may be fixed after vacation.
যিটো অডিট ৰিপৰ্টটো আহিব নহয় আপোনাৰ তাতে ৰিডিংছ কমপ্লিট কৰি দিলে নহয় সেইটো আপুনি পাৱা নাইতো
My lord, the final audit report has not been received, my lord. Liberty may be granted, my lord, to file,
File additional
maybe recorded, my lord, otherwise.
that the respondent authorities have not enclosed the audit report along with their affidavit. The doctor submits that it may be granted liberty to bring on record the final audit report by
As and when
additional affidavit.
As
That
and,
is recorded here.
as and when received, my lord, we are waiting.
Not as and when you have to. Before next day.
26. Much obliged, Lordship.
May it please Lordship, my lord, this matter pertains to non-payment of full and final debt gratuity to the petitioner. It is payable on the debt of her late husband, my lord. The admissible amount of debt gratuity is 20 lakhs, my lord. But the petitioner received only 4 lakhs 42,402 rupees. The remaining 15 lakhs 57,578 rupees has been deducted by the respondent, my lord. So it going to a mediation would not suffice justice to the petitioner, my lord. I pray that this may be heard.
Can I refer it to the mediation?
No, my lord, no.
So you are appearing for?
I'm appearing for the respondent on behalf of Mr. R.K. Little.
Department, which department?
CRPF.
CIPF.
CRP.
CRPF.
You have filed your affidavit,
Yes, Lord. Affidavit has been filed.
Hardness,
Kiwa Pangla.
Learned Counsel for the Hardness,
L. Leahy, Lord.
and David, Learned Counsel appearing on behalf of Mr. R.K. Learned additional or
Deputy Solicitor.
deputy solicitor for the respondent authorities. The Learned Counsel for the submits that no purpose will be served by referring the matter, the mediation law is listed under the column. It further submitted that the pleadings have already been completed and the internet for admission. Accordingly, it provided that that's the matter for admission hearing immediately after the opening of the vacation.
Okay.
Items for admission, item number 11, target rate.
My lord,
my senior Mr. Ken Chaudhary argues for the university. He is not, he's not in the court premises today, my lord. They're seeking an adjournment. If your lordship be pleased to fix the matter on the next Thursday, my lord, because on Tuesday we have a few matters only. Mr.
No,
Vijay-
Lordship, actually senior will come today. Not now, actually, adjournment for timing. But
Oh, time being. Okay, I thought. So 9 again.
Who is here?
My senior is PJ Fukun, but this case is leading by Ken Chaudhary sir. Keep your place.
Number 40.
Lordship. Lordship, we've tried to file affidavit in reply yesterday actually, but we could not submit the copy to the respondent side. Because we
Not
didn't get
difficult.
any.
Matter may be heard, my lord.
Okay.
Because there is an interim order, my lord.
Lordship, we have filed.
There was an advertisement, my lord. He has not supplied the eligibility criteria papers, my lord. There is an interim order operating, whereby the appointments have been stayed, my lord.
Lordship, we filed one affidavit in reply yesterday, but we could not serve the copy on actually.
No difficulty, my lord. Let him serve it to me today, my lord. Let it be taken up now.
Lordship,
Whether it is,
Lordship, a short date may be fixed, Lordship. Very short date.
when did you file?
Lordship,
Duta Bazar low by the
3rd of September. Lordship.
3rd of September.
September.
But our computer shows that it is.
No, actually, we could not serve them the copy actually. This is the reason why the filing was not completed.
Thanks.
No, one week, Lordship, 1 week.
Tuesday, my lord.
Third, third,
US Pora.
third, all the respondent,
All the respondents. 2 and 3, my lord. 2 and 3.
who is for what?
I'm for one lot.
One is a formal party.
The learned counsel for the period of some extent, he has filed one affidavit in the certain that we have record, but I also did not serve a copy. According to principal mistake, provided that the vendor on the next
Tuesday, my lord.
Lordship.
9th, my lord.
Obliged.
And number 52.
Mayor, please, your lordship. The matter pertains to selection and appointment of constable under the Central Armed Police Forces. Earlier occasions, CJC took time to file affidavit. I think today is the last day to file affidavit. We're awaiting lordship, although we have qualified all the tests, but we have not been selected and we secured more marks than the last candidate who is for appointment. So that's why lordship, this CJC have been on last occasion. Not only last occasion, earlier occasion, they took time to file affidavit. But till then, we have not.
My lord, actually, my lord, what happened, I accept notice. I have sent a letter to the circle officer of Udalguri only, in each and every cases, because I think, my lord, they have not served the other copies, other parties also there.
No.
No, if they served them, I would check it up, my lord, because I have only sent to the circle officer. That's why, my lord, some time may be required to obtain instruction from the, my lord, DGP, IGP, they are the main party, my lord. The
Yes,
circle officer,
yes,
he only issued the economic certificate.
Lordship, here, lordship, main authority is the lordship, the.
Yeah, my lord, 5, 6.
Let me say.
No. First of all, to see whether he served a copy or not, my lord.
Why not?
Yes, I will see, my lord. Without going through it, but we are not unable to obtain instruction.
We have taken.
We have only sent to the circle officer. He said every cases from them. How many copies they have served it?
Lordship, for a moment, let me go through the lordship record of the other, whether I have taken steps or not. So for my knowledge is good, lordship, in each and every case we have taken steps. Now, my learned senior has submitted, we have taken not.
But that's why I want to
This is
clarify.
not the way to-
Why I have sent only one copy, my lord.
Here, lordship, the main concern to file affidavit is the CGSC. The circle officer came into in the field because they have issued the EWS certificate. Now, whether my EWS certificate is genuine or not, that question does not arise at all.
Now here, Lordship, the moot question is why the petitioner have not been selected, although they have scored more marks than the last candidate who got appointment. That is the issue here. That's why Lordship on the CJS have been directed to file affidavit. But today they are not present here. I think today is the last time. Last chance is given.
Who is here?
SS Roy.
SS Roy, my lord.
After some time, court master will inform.
Lordship, immediately after a week fix the matter, I will inform him, Lordship. I know him, Lordship. He is supposed to file affidavit. After a week, that may be fixed, Lordship. I will inform him.
That's agreed by Lord.
Otherwise, Lordship, he is file affidavit. After
a week.
a week, Lordship, any day, Lordship.
You are appearing.
I am appearing for my lord, respondent number.
Today is for, on 11th, Lordship.
Well, I am appearing for respondent number 4 only.
Number 4, may file affidavit.
So,
If it is not inconvenient, Lordship, on 11th of August, September, Lordship.
Oh, ঠিক আছে,
That
বলুন।
will be fixed by the next.
ঠিক আছে, অকল আমি এটাহে আছো। বনাই দিও।
No, Lordship, otherwise, Lordship, there's an urgency is there because in the meantime, Lordship, new advertisement is come, Lordship. So,
মাথায় দিলে?
before vacation, Lordship, after 11, but before, prior to vacation. If you delay, 23rd of September. 15 days.
তুমি আছা নেকি?
I am paying for Mr. Assessor, ma'am. We are sending the every for vetting. So we need some time.
Okay, 25th.
25th.
Lordship,
25th.
25th September.
And so
Development.
The order for affidavit for SS Roy.
Yes, ma'am.
CGSC, Lordship.
Hybrid food puna, sir. Hybrid food puna, sir.
Yeah.
Copy diyan hai, sir. 6 per copy.
Obliged, Lord. May I please, Lordship?
The petitioner before your lordship is a lady doctor, my lords, who is serving in BSF. My lords, we are assailing two orders. One is a transfer order, one is a movement order. My lords, the issue is she was rejected. It's a policy of the BSF to transfer personnel, my lord, after completion of 3 years. Here the issue, the hurdle the petitioner is facing is, my lords, her two daughters are in the midst of academic sessions and which cannot be changed. And secondly, my lords, when I was transferred and I have to relinquish my charge, and then, my lords, by another order dated, my lords, which also is assailed, my lords, a movement order was issued, which is under interim, my lords, it has been stayed. Pleadings has been exchanged, my lords. See, lordship can take it up for hearing. My lords, exchange, my lords.
Lordship, fact is that he is an anesthetist and it is in a BSF hospital. So as there is a stay, so we are facing it difficulty, Lordship. In fact, transfer order, subsequently she had submitted another application seeking child care leave. That application, she asked for 365 days, but as she is a doctor in a defense of BSF, and there is only one anesthetist where she was transferred. At present, she was transferred to Agartala, though she had not joined, Lordship. So we cannot, at one time, we cannot allow her for 365 days. So we provided her 90 days CCL, which was applicable from 16th of May. She had availed that. So transfer is perhaps out of two, she had already availed that CCL condition, Lordship. 90 days CCL is over by 13th of this August, 13th of August, that CCL is over. Now it has to be, thereafter it has to be counted from her other leave. But at this stage, Lordship, what I suggest that she can join and she can file a written application seeking that there is some other facilities, because it's not that we have denied her. We have given her 90 days, she had availed that CCL. So there is no question of challenging that transfer because she had given relinquishment order, she had signed herself. And now that CCL of 90 days is over, neither because of the stay she had not joined, and we are in a very disturbed situation, Lordship, because she is the only anesthetist in that hospital, Lordship, in defense BSF hospital.
In that issue, my lords, what has happened, the authorities have violated their own OM. What has happened, this petitioner's husband is also working under Ministry of Health, is posted in Negrims in Shillong. Whereas they have a policy which says at page 33, Lordship will find at the read petition. He is a doctor, he is permanently posted as a non-transferable job. 33, my lord, it governs the post, it's, the heading is posting of husband and wife at the same station. Page 34 is relevant for me, my lord. Page 34, lordship has got. 34, my lords, point 3. 3 and 4. So the practice is, my lords, if one of the spouse it belongs to central, both of the spouse belong to central government, my lords, of different organizations, there should be an endeavor, according to this policy, my lords, that there should be one of them should be stationed, should be transferred and posted in a place nearby, my lords. He is posted in Shillong, which is non-transferable, and this petitioner is in Rani Patgaon, my lords. There is also violation. They are transferring me to the to Agartala. I'm not saying transfer is bad. My lord, what is the hurdle I face is my two daughters are studying in Guwahati under ICSE board. One of them is in class 10, one of is in class 8. And changing in the midst of the academic session would cause them trouble, my lords, and harm their academic interest, my lords. Two daughters, my lord. Had been a two boys, my lord, we could have understand. These are two daughters, my lords, and she is the only caregiver because husband is posted in Shillong.
Transfer was of 30/4/2025, not now. 30/4/2025 at that time, the transfer order was. And she was, from the date of her joining, she was in Shillong for 4 years and then Guwahati 4 years. So in a central government service, one cannot choose always the place of posting, and she has been transferred to Agartala. Here, one vacancy that has already been filled up as per her, as she had given the relinquishment order also. So it's not possible to retain her here because the other incumbent had already joined long back. And the order is of 30/4/2025.
And then if lordship, another issue, lordship will hear in detail, my lord. Lordship, I have filed an affidavit in reply. In affidavit in reply, I have annexed a policy. What is the BSF doing, my lords? They have created two separate sections. Beyond the DIG, my lords, DIG, IG, when their transfers are considered, it is specifically, there's a guide that academic lordship will kindly find page 56, my lord, of the affidavit in reply. Page number 56, it starts, my lord. Annexure 4 of the affidavit in reply. Oh, my lord, it starts from page 42.
70.
No, additional affidavit. Reply affidavit. Additional affidavit. Policy Conversion Act. I'm sorry, my lord, it's at page, this starts at 89 of the affidavit in reply.
Maybe, but it is nothing challenging this.
Yes, lordship.
No, my lords, I have a different issue, my lord. This has been, see, it has not, lordship can mold the relief, my lord. Here, lordship will find the DIG, IG, when their transfers will be affected, academic interest of their school-going children will be kept in mind. That is page 93, my lords, at the bottom.
No, if I've already relinquished the search.
No, my lord, sir. That has to be put on record because the qualification. The person, my lords, I am a MD anesthesia. The person who has been employed in my absence is now just a PG holder, just a diploma holder, my lords.
No, we will not go into that.
No, that apart, my lord, the Supreme Court, my lords, while considering these issues, I will kindly have a look at this. My lord, the childcare leave and the protection of a woman in serving in force has been dealt with, my lord, here in this matter, my lords.
No, it's a Gogoi. Is it your case that your childcare leave has not been granted by the?
My childcare has not been gifted. They are saying they are coming with a instruction. They are coming with a plea that no, we cannot grant you 365 days at one brief period. Only you are entitled to 90. But whereas that 90 is in, my lord, it doesn't serve my interest, my lord. It has to be 365 days or I'm not asking beyond that also, my lord. I will forego every leave, my lord, but since my childs are in school, my lords, they are pursuing in Guwahati, my lords, it's not possible to change now the school boards, my lords. And it's a guidance of it's under ICSE, my lords. That decision, my lord, will see
Academic session will over.
March, my lord, next year.
We are not saying 90 days she had already availed. Then another few days had been gone, lordship. Prior to that also, from the date of her application, now there is no necessity of 365 days. Even perhaps it's less than half or about half till March, lordship. We have few months. So we are not denying. We will say that there is a provision that one can apply for childcare leave 3 times maximum in a year. So this year also she can, with the as per the the only authorities at Agartala, they can give her, she can submit her representation. Then sometime that she join her, she do some time of service, then she can again ask for. We are not denying also that they are the appropriate authority to grant or not to grant. Because she had availed 90 days, that they have granted. They have not said that we are denying her. 365 at present is not necessary because she had already availed 90 days. Thereafter, prior to that also some days and that also. So instead of keeping it pending and now she is on a stay, we are facing difficulty. She is of no work here. She just enjoying her leave. CCL has over by 90 days. Now it has to be counted from other leave also. So at present, 365 days is not necessary. So the prayer that 365 days, she had availed 90 days. She cannot ask for now that we have not granted her 365 days. 90 days she availed.
Well, in that case, I'll fall back on point number 1. When you are transferring me, you should have considered according to your own OM, the space station nearest. By any stretch of imagination, my lords, Shillong and Agartala, they don't match any way, my lords. That is also, I have averred in my writ petition. I have demonstrated that clause, my lords. That is there. Secondly, again, my lords, that the third issue, which no doubt, my lords, we have not assailed that, but that is also their policy, that officers below a rank of IG, DIG, when they were transferred, the academic session of their students will be taken into account. Whereas I being a, my lord, very junior officer, doesn't my children also have, this policy is creating, my lords, arbitrariness, my lords. 14 and 16 are being hit article. Because IG's child are child, my lords, had been, and these are minor, my lords, had been these children, these 2 daughters, my lords, these 2 daughters go beyond 18, then I could have amended to their prayer. But my lord, these are 2 daughters, my lords, which are still minor.
Lordship, CCL is for minors only, below 18 years. So they should have to be minor if she is availing CCL. Except disabled children. Disabled children, there is no age limit.
And I tried to take some instructions from Agartala also. What I have come to know that the hospital is managing well. They are taking on-call basis anesthesias from the Tripura Medical College.
They are arranging, Lordship, but that is a stopgap arrangement. If someone is serving and she was
Okay, that's not prepared with all
My lord.
your instructions.
Well, yes.
7 years she was in Shillong and for more than 4 years in Guwahati. And now she just cannot say that her husband is
just
in
asking, my
Shillong.
lords, till March. My academic session is over. I'll join wherever they want, my lords. Lordship, let them have some instructions regarding the qualification of the person who is specifically.
That is with me, Lordship. Just now I can place. although it is not in a written format because that's not necessary. The person who had joined, she has qualified in MD anesthesia from prestigious Armed Forces Medical College, Pune, who is posted against the petitioner here. In fact, she is a diploma holder, the petitioner, and she is a MD anesthetist, the present person who is posted in her place.
Is the matter after one night?
My lords, one. My lord, there's a
Fixed-
interim, my lords.
Fixed date may be given, Lordship. No, Lordship, then some difficulty.
24, my lord. My lord, there's a interim, my lord. Obliged, my lord.
Made to Lordship. In this case, I have filed an implement petition, Lordship. Implement petition may be allowed, Lordship. But the implement is that I am an association of the headmaster of the school. By this petition, Lordship, some contextual teachers got a interim order that regular headmaster post should not be filled up, Lordship. Government has decided after 33 years long back, Lordship, to decide to create the post of regular headmaster. It's an interesting case. There is no regular headmaster from since 1972, Lordship. There is no post headmaster. But government has decided, however, after our demand, that it should be filled up, Lordship. So my presence is necessary to say that all Assam Teachers Association, we are demanding and we are fighting various memorandums, and without implementing us, Lordship, they have filed, Lordship. My prayer is to implement me, Lordship.
I have no objection, madam. Regarding implement, I have no objection.
The also learned applicant or that's
Petition I haven't got.
Respondent number 8.
In here,
Three and four.
3 and 4.
In the IA.
I, Lordship.
I have 2 books. I have 8 and 9.
8 and 9, Lord. 8 and 9, yes.
8 and 9.
Sir, Katunya po
I am for the
6 and 7.
6 and 7.
The format is there? No.
1 and 5 read petitioners, Lordship, but
yeah, yeah.
Applicant for the for the
5 to 7.
That's what I don't know. I mean, it's good, no? For sure.
5 to 7. 5, 6, 7.
Also, Mr. Time of the number
Number लिखा नहीं
Respondent number 5, 6, and 7. If the order passing the IA, also order amended state of the topic 8. What are you doing?
Lordship, I will file amended cost title.
2694.
I may be allowed to. Applicant.
94.
This has to go to the newly inflated person.
Sorry, madam.
Notice has to go to the newly inflated person.
No,
No.
He's
Lordship.
present. He's praying for implement, madam.
I'm paying him.
Going to return copy to us, sir, madam.
Please, Dr. One.
My lord, date may be fixed, my lord, because we have some urgency, my lord. Because of a interim order, my lord, we cannot proceed with the recruitment, my lord.
Government has mentioned.
19th of September. Common 18 crore. In the meantime, my lord, petitioner may file a reply, my lord, because we have already filed our opposition.
I am not petitioner, Lordship. Petitioner is not here.
Obliged, lordship.
My lord, I am for the respondent. And Mr. Sharma is appearing for the appellant.
Present or
Mr. Sharma,
present or not?
I don't know, my lord. Let it be taken up on 24th, my lord, this month, before vacation, after vacation, my lord, then.
Not the case for the appellant or the you are Mr. Hussain.
Yes, my lord.
That I not for the president. Take the matter immediately after the offense of the big. The event of something will not be repetition of the event that will be ordered.
Much.
May I please, as a lordship? My lord, this matter was heard on the last occasion also, my lord. My lord, a cabinet decision has been, my lord, approved and taken up by the state cabinet, my lord, for the purpose of, my lord, bringing us at par with the other category of teachers for getting the fixed pay salary, my lord. And accordingly, my lord, some of the persons, my lord, from that cabinet, my lord, has been given the benefit, but we have been later on left out. Now, my lord, while the cabinet took a decision, my lord, a detailed inquiry from the school level, from the inspector of school as well as from the deputy commissioner, my lord, was taken into consideration by the state cabinet, and then only, my lord, we had been recommended.
Yeah, excited and said.
Yes, sir, that is correct, my lord. My lordship actually on the last occasion wanted some judgments, my lord. My
Yes.
lordship has already relied on that once the cabinet take a decision, my lord, the executive do not have the power to revisit or, my lord, can alter or modify that decision, my lord. My lord, I have found 3-4 judgments, my lord, which I will provide, my lord, in due course, my lord. The soft.
Not now.
My lord, we have that list, my lord, but some technical issues is there, my lord. By within an hour, my lord, we can submit, my lord. If my lordship can.
Okay, we'll take it up after some time. In the meantime, court master will inform the council for the response.
My lord, my lord. A senior friend is also there, my lord.
Item number 26 is mine.
Okay.
I will after I will argue. I have some different point on this point. I will argue.
Like, come prepared with those decisions.
My lord.
May I please, your lordship? I have completed my argument on the last occasion, Mr. You have to make the response to them. Arbitration. 22. 23 arbitration.
May it please your lordship, I apologize, my lord, in midst of the hearing. I was on legs in court number 18, my lord. For item number 22, my lord, for that Jinumoni case, my lord, item number 22. I was on legs, I came running, my lord, because There was an we have already filed the objection petition today. Yes, my lord, we have already filed the objection, my lord. Because they were not a necessary party in that. Even they are not TET qualified.
IA was for implement.
Implement, my lord. But
Why
they,
you were objecting?
because they don't have any rights, because they are just an association. And in fact, therefore, yesterday, the Supreme Court also came up with the judgment saying that for any promotional activity, you have to be TET pass. They are not even TET qualified. Whereas we are TET qualified, we are working from 2012.
Okay, we have already fixed the matter on.
So, my lord, may I at least fix the matter for objection for the implement hearing, my lord.
No, that petition has already been disposed of.
No, my lord, because we have already filed, our objection is already on record, madam. We already filed today.
At that time.
I understand, man. I absolutely sorry, madam. I was on legs. I'm a single person. I was on legs on 18, my lord. There's a recorded also, madam.
That has already been passed.
My lord, may just, I beg before, my lord, I'll call the other parties because, my lord, because we have already filed the opposition, and in fact, we gave them a copy today. We gave them also copy.
They have, nobody has pointed it out.
My lord, may just reconsider.
Next day we will say not.
If I may, my lord. I am appealing for the respondent, my lord, on behalf of Mr. S. Bothakur. He's on legs in another court, my lord. So I'll be arguing on his behalf, my lord. My lord, if I may take my lord to the petition which was filed before the trial court first, my lord. Before advancing my argument, I would like to state, my lord, that the order has some infirmity, my lord, that needs to be interfered by this honorable court. On the last date also I have stated before this honorable court, my lord. Starts from page number 20, my lord. I'm sorry, my lord. Starts from page number 29, my lord. If I may take my lord to page number 31, the schedule, my lord.
Yes.
Page number 31, my lord, not schedule, my lord. Leave encashment, GSI cover benefit, GSI accumulative value of savings, family pension, gratuity and GPF, my lord. As regard to the family pension, my lord, the law is settled, my lord, that cannot be a part of the estate, my lord. If I may place a judgment, my lord. Violet Isaac, my lord. Fifth paragraph, my lord. Paragraph number 5, just the paragraph above paragraph number 6, my lord, the subparagraph. The court further held that what was not payable during the lifetime of the deceased, over which he had no power of deposition, could not form part of his estate, since qualifying event occur on the death of the deceased for the payment of the family pension. Monetary benefit of the family pension cannot be form part of the estate of the deceased, entitled him to dispose the same by testamentary deposition, my lord. So family pension as regard to, my lord, that cannot form a part of the estate of a particular person, my lord, of a deceased. So, my lord, the judgment as regard to the family pension, succession certificate given for the family pension, that has to be, my lord, taken care of by this honorable court, my lord. Rest, as regard to rest of the, my lord, estate, my lord. Just a paragraph before the schedule, my lord. The prayer which has been made in the, my lord, case. Under the facts and circumstances, the petitioner prayed for the succession certificate may be granted to the petitioner in respect of the debt and security set forth in the schedule hereto with power to. Now, my lord, if I may take, my lord, to the reply that they have filed, paragraph number, page number 35, my lord. Page number 35 of the reply. May I, my lord? In the aforesaid background and relevant document, it is very much clear
that the present OP living along with Subal Borua as being a legally married wife and as per law of succession, she is entitled to have a share over the debt and securities left by the deceased, so and so, my lord. So the appellant herein has admitted the prayer. Her only prayer is that I should be also entitled to all the debt and securities, my lord. That is the only prayer, and accordingly the decree has been passed, my lord. The judgment and decree has been passed. So the infirmity as regard to the judgment and decree only is as regard to the, my lord, the pensionary benefit, family pension, which my lord will have to interfere with all due respect, my lord. But as regard to the other estate, they have clearly stated in the written statement that they do not have any objection as regard to they are also entitled. Certainly they are entitled to a portion of that. And the judgment has been rightly passed. So the grounds apart from which has been raised in the appeal, apart from the family pension part, those, my lord, stands as it has been passed now. And my lord will have to consider one thing, that this is not a writ court, my lord, this is an appellate court. The pleadings, my lord will have to go by the pleadings that they have made before the trial court, my lord. And there is no pleadings as such that they are not even entitled to the family pension. That will also will have to be satisfied by them, my lord. They have not specifically made any statement that they are not entitled, that we are not entitled to the family pension. They have not stated, my lord. Their only prayer as regard to the that they should be entitled to be, my lord, all the benefits as we are, my lord, as legal heirs of the deceased, my lord. That is the only grounds they have taken, my lord. Several grounds they have taken which they were not raised in their written objection. They have the grounds which they have not raised in the written objection, my lord. So the rest of the grounds may not be considered by this honorable court, my lord. It is only at regard to the infirmity and law which is caused by the trial court that aspect needs to be considered by my lord. Not rest of the grounds which they have raised. The grounds which they have taken, my lord, in the appeal, not a single ground was taken in the written objection, my lord. My lord will find the grounds from page number 9. These are the grounds, my lord. First ground, my lord, for the learned trial court has erred in law as well as in facts in directing the issuance of a joint succession certificate in favor of the appellant along with the opposite party number 1, 2, 3 in respect of the debt and securities left behind by the deceased so and so the husband of the appellant, which are nothing but the service benefit of him, as that being so the impugned judgment and order dated so and so passed by the Court of Additional District Judge Nagaon in mis succession case number so and so is liable to be. This also ground was not taken, my lord, by them. Second ground, my lord, for the learned trial court have in direction the issuance of the joint succession certificate in favor of the rival parties have clearly erred in law, especially with regard to the interpretation of provisions of section 372 of the Indian Succession Act, as because it is settled provision of law that joint succession certificate cannot be directed to be issued in favor of rival parties to the proceeding under section 372 of the Indian Succession Act, but have done so have vitiated the entire process and the consequences that the impugned judgment dated so and so passed by the Court of the Additional District Judge number 3 Nagaon, this case is liable to be set aside in quest. Further, the learned trial court has seriously erred in law as well as in facts in along with the application filed by the opposite party, wherein for seeking the succession certificate in connection with all the service benefit of the deceased, late so and so has been service benefits of the deceased can by no iota of evidence be construed to be debt and security of the deceased in as much as a deceased employee does not have any title over the family pension, as because the family pension of the deceased employee undoubtedly is not part of the estate of the deceased employee. In consequence, the same cannot be made a subject matter of the Indian Succession Act. So and so, rather that would always be regulated by the pension rules, which confers a statutory right to the beneficial established do the same, and that being so, the impugned judgment and order dated so. So these are the points they have raised in the appeal, my lord, which I'm not contending, but they have not raised these particular issues before the trial court, my lord. further the learned court below have seriously erred in law as well as in facts in directing the issuance of joint succession certificate in favor of the opposite party, and the appellant herein, in spite of coming to the specific finding conclusion to the effect that the appellant herein is legally married wife of late so-and-so, and also hold that nothing was disqualified, nothing will disqualify her from succeeding to the estate of her late husband, as because it is a settled position of law that a claim for succession certificate cannot be granted to any other than the wife of the deceased employee if she is alive, and that being so, the impugned judgment and so and so. Point number 4, my lord. For the learned court below, in passing the impugned judgment order dated so and so, have seriously erred in law by way of completely overlooking the law governing grant of family pension and other service benefit to the deceased late so and so, as it has been specifically laid down under the Assam Service Pension Rules 1968, and that being so, the impugned judgment and order dated so and so passed by the court, honorable court. The 6th, my lord, for the learned court below, in allowing the issuance of a joint succession certificate in following of the mother of the deceased, that is opposite party number 1 herein, as well as a married daughter of the deceased, in total contravention of the law governing granting of family pension and other service benefit. Often deceased government employee has been completely vitiated, and entire proceeding more so miscase is not at all maintainable so far it relates to family payment of family pension and other service benefits of the deceased. May I please place another judgment of the Allahabad High Court, my lord? AIR 2001 Allahabad 195, my lord. AIR 2001 Allahabad 195. Paragraph number 7, my lord. I have considered the arguments. No doubt, it was true that the application along with made by the application for issuance of succession certificate. However, the opposite party filed objection and requested that the succession certificate be issued in their name. Therefore, the controversy in this case regard to issuance of certificate could be decided, and it was not necessary for the opposite party to move a fresh application for the issuance of the succession certificate. The opposite party in their objection made a request for issuance of certificate, and therefore, for the purpose of section 372, 373 of the Indian Succession Act 1925, the opposite party shall be deemed to be applicants in the issuance of succession certificate. There is no bar that succession certificate cannot be issued in favor of all objectors. So a succession certificate can be issued in favor of the objectors also, my lord. The multiplicity of the suit should never be encouraged. The matter for issuance of the succession certificate question could be decided in the application moved by the applicant itself, and therefore there was no necessity for moving a fresh application by the opposite party. The entire evidence was considered and the certificate has been issued in favor of the person found best entitled. So it is not that only that the applicant, the succession certificate is to be issued only in favor of the applicant. Considering the facts and circumstances of the case, the evidence adduced in the case, succession certificate can be issued to all the my lord, even the opposite parties, my lord. And my lord, may I please place another judgment, my lord, of the Supreme Court?
On which point?
This is as regard to that the court cannot go beyond the pleadings, as they have not raised these particular issues which they have raised in the appeal before the trial court. So, my lord, it binds this honorable court in appeal, my lord, not to consider those aspects, my lord. May I please take, my lord, to paragraph number 9, my lord. Citation to AIR 2014 SC 1290. Paragraph number 9, my lord.
Yeah.
This court has consistently held that the court cannot go beyond the pleadings of the parties. The parties have to take proper pleadings and establish by adducing evidence that by a particular irregularity or illegality, the result of the election has been materially affected. So the court, the facts have to be put before the, my lord, trial court. And certainly, my lord, section 101 of the Indian Evidence Act come into play, my lord, that when a particular party requires a decree to be passed in his favor or her favor, he has to raise that particular and he has to adduce evidence to that effect, my lord. With this, I conclude, my lord. There's certainly the judgment needs to be interfered by this honorable court only as regard to the family pension, my lord. But this also aspect needs to be considered that they have not raised that particular issue before the trial court, my lord.
But you see, Mr. Sethua, the judgment of the Allahabad High Court, no reason has been given as to why succession certificate cannot be used in favor of the.
That is as regard to multiplicity of litigation, my lord, because all the successions, all the persons come to the court, my lord, all the legal heirs come to the court asking for separate, my lord, certificates. The court has rightly gone, the trial court has rightly gone and issue a, my lord, succession certificate as regard to the applicant before the court as well as the opposite party before the court, those who are entitled to the, my lord, the estates, my lord. Only as that regard, I'm pressing on that judgment, my lord.
So this was any reply?
May I please, Your Lordship? Now, Your Lordship, the arguments advanced. One thing I just want to point out that the grounds I have taken are the judgment specific. It cannot be expected by a litigant to know what is the judgment to be passed, because the judgment I have, some of the grounds which they say that rightly I have not taken in my objection filed in the succession certificate, because those grounds are the judgment specific. Because the judgment was erroneous, I have raised those points, and it cannot be expected of a litigant to know beforehand what the judgment would be pronounced. So the contention that these grounds were not taken at that point of time has to be taken with the factual aspect. Now, with regard to their submission, with regard to the fact that on one hand, they are admitting that the trial court was erroneous in entertaining the succession case filed by them. I was an opposite party in that case, filed by them on a basis of securing the pensionary benefit. But they say that with regard to the other aspect, it can be considered. But the fact remains, Your Lordship will kindly appreciate, as per the provisions of section 370, under which a succession certificate is issued, it is only with regard to debts and security. A service benefit, I have placed judgments on the earlier occasion, Your Lordship. Service benefits of a person cannot by any iota of evidence be come within the ambit of debt and security. Because all the claims that my learned colleague had drawn, the schedule they had filed along with their application, are totally and directly related to the service benefits of the deceased person. And the wife was made the opposite party. The mother and the two major daughters and married daughters were the applicants therein. And one statement was there, though that was not pleaded in the objection. But fact remains that both the daughters were married, though while filing the application, they have contended only one was married. Now, with regard to the mother also, the issue, it was not that our main contention was that the application filed by the mother and the two major daughters and married daughters was not maintainable. And though it was not specifically there, and because they cannot be constituted to be dependents with regard to the deceased person. And our main contention before this honorable court as well as the trial court was it should be guided by the rules framed by the pensionary rules. here it cannot be disbursed. Now, section 70, which I had drawn your lordship's attention, is clearly with respect to debts and security, which I again reiterate that pensionary benefits or other service benefits by no evidence. Now, again, the schedule may be looked into, your lordship. What was the schedule that they had claimed for at page 31, which my learned colleague had referred? These, they say, are debts and securities, because the heading is schedule debts and security lying in the name of the deceased. Leave encashment, GIS coverage benefit, GIS accumulative value of saving, family pension, gratuity, GPF. These are, my humble submissions, are not at all in any legal parlance to be considered to be debts and security of a person. These are the things which are against the service rendered is given. It cannot be claimed as a debt. And I have placed judgments even on earlier occasion with regard to joint certificate also. I have placed, your lordship, that which your lordship had stated, and even in where reading of the provisions, it is clearly stated, if I may just read out, your lordship, subpara to section 370. Provided that nothing contained in this section shall be deemed to prevent the granting of a certificate to any person, not persons. It is, even the statute does not quantify plural with regard to that. And I had placed a judgment, I think it would be in the files, your lordship, 3 judgments of one of the Bombay High Court, or 2 Bombay High Court, and one of the Allahabad High Court. I think it should be in the case records, your lordship. Lordship, 3 are from Manupatra citations I have given. From Manupatra, if it is on record, where a division bench had in an application, it is there, I think it can happen. If it was Manupatra MH 0021
Yes.
1891. One is that it is a division bench judgment whereby the court, following case of a Madan Mohan case, that is of Allahabad High Court, had clearly stated that granting of a joint certificate is to frustrate the object of the act. This is one. And the judgment which it was based upon, I had also placed before your lordship. That is a Manu UP 0090 oblique 1882. It is Madan Mohan versus Ramdayal. It is also a division by judgment, where in para 2 it had been specifically stated, we have no hesitation in holding that the grant of a joint certificate or 2 more certificate is not only fraught with oblivious and inconvenience, but is opposed to the whole spirit and policy of the act. So this is again what I have pleaded, your lordship. And again, in another judgment, which is in Manu MH 00751 886, Jamna Bhai versus Hastu Bhai, where in para 4 again the same proposition has been specified. The last few lines, your lordship, in 3rd page, if your lordship, I think it had, that it is not necessary to decide how the rights of the widows are to be worked out under this in any case. We are of their opinion that it will be frustrating the object of the act if we are to grant the certificate to both the widows. And we think under the circumstances, the widow to whom the estate vested on this has a better claim to be entrusted here. Now here was both were the widows, and even in that circumstances also, the High Court in its wisdom did not proceed with granting a joint certificate. Here is a totally different aspect, Your Lordship. So our allegations assailing the impugned judgment, on the last occasion, I had pointed out that it cannot be termed a debt set security, as well as I had pointed out on the earlier occasion that joint certificate is totally alien to the concept of succession certificate. So we are on this issue, Your Lordship, and the widow, the applicant is the named person. He is the named person. He is named in the service record as the beneficiary. And Your Lordship will find that the pleadings are law points need not be urged at any, means it can be urged at any stage. There is no requirement or hard and fast rule that it cannot be raised in the appellate stage. These are not factual aspects which I am pleading, Your Lordship. The pleadings which cannot be done at a later stage are pleadings which are based upon facts. Here, all the points which I have urged before Your Lordship through these are all legal issues, and legal issues can be urged before this court at any point of time. Because the whole concept is with regard to grant of a succession certificate or entertaining a succession application filed by the mother and two major daughters married with regard to the pensionary service benefits of a deceased and making the wife as the opposite party. And the maintainability of such an application was first objected to, and thereafter the trial court, while coming to the fact that I am also the married wife, had proceeded in granting joint certificate to all four of the parties, which is totally alien. That is the whole point here. And the Assam pension rules would govern the whole thing. Assam pension rules, because he, the employee, the deceased was an employee of the government of Assam. So that particular rule, which I had placed on the earlier occasion, would be governing the disbursement here. And section rule 143 is the relevant entry, Your Lordship, which I had pointed out on the law. Highly obliged.
Item 28.
Obliged, ma'am.
Please, Your Lordship. Lord, is a case for application of the doctrine equal pay for equal work. The petitioner in the instant case, my lord, they're district level engineers in Sarva Shiksha Mission, and they were appointed to this post by an advertisement which is available at page 34 of the writ petition, Annexure A. This is the typed copy of the advertisement. Lordship may kindly take note of.
After some time.
He was very much here on this. Very much here. It's coming probably, Lordship may allow me to continue, please, my argument. Otherwise, Lordship may come to page 35. Serial number 4, District Project Engineer. Essentials in the second column.
B in civil engineering from recognized engineering college institute recognized by AICT, or diploma holder with minimum 15 years of experience in government departments, undertaking, or private engineering firm. So, my lord, essential qualification criteria which was introduced in this particular advertisement was that B holder, B degree holder, or diploma holder with 15 years of experience. So these two categories were equalized on this particular basis, that they were equalized on the basis of imposing the condition of 15 years of experience with diploma. So accordingly, the writ petitioners, there are 13 numbers of writ petitioners, they had applied for the post and they qualified. And accordingly, they were appointed. And the scale, your lordship may kindly take note in the scale given in the fourth column, in the same advertisement. And this scale, a uniform scale, an identical scale was given to all the engineers. Some of the engineers were B degree holders, and this set of writ petitioners who were diploma holders with 15 years of experience, they were also given appointment and they were also given the same scale. Lordship may now come to page 66 of the writ petition. This is the rule whereby the services of this district project engineers are governed. At page 66, Lordship may kindly take note of the essential qualifications given. B degree, B engineering, of the equivalent qualification having 10 years of experience in the government department. Diploma holders with minimum 15 years of experience. So my contention before this honorable court is that whatever was brought in the advertisement was in consonance with the provisions laid down in the service rule. That here also the condition of 15 years is there. And this was introduced, this was, my lord, this was imposed in order to equalize these two categories of employees. And accordingly, they were treated equally from the inception in terms of their payment, in terms of salaries and everything. Then, my lord, the impugned order is at page 121, Annexure C. And the relevant portion is on page 123. This was the notification whereby this ROP was introduced, and these two, one single post were divided into two categories at serial number 13 and 14, and one was designated as district project engineer and other is as district project engineers if qualification is below PE, and two separate pay band was introduced. Now, my lord, our plea before this honorable court is that we are entitled to the doctrine, the benefit reserved in the Constitution of India for equal pay for equal work. Since here in this case, we are not in a similar post, but we are functioning, we are working in the same post. Same degree of responsibility, same degree of skill is required, same degree of efficiency is required, and we are discharging it, we are performing our duties without any complaint, without any objection from any quarter. And we have been working in different locations, in different districts, and sometimes interchangeably, sometimes this position district, this is occupied by some B, and in the very next moment it is occupied by It is filled by some diploma holders with 15 years of experience. Since we have already been equalized in terms of our educational qualification by imposing the condition of 15 years of experience right from the inception, so we cannot be subjected to further discrimination on the plea that we do not possess the required, our educational qualification is different, it's not at par. Whereas it has already been given in it is provided in the rule itself that we are at par, we are equivalent. In other cases, there are series of judgment, my lord, series of judgment of the apex court. Some of the judgment will be relying on, some other will be relied on by the other adversary side. But thing is that which one will be the suitable one, most suitable one to be applied in the given case, this particular instance? Because I have verified, I have gone through the judgments passed by the apex court in this particular context. In majority of cases, my lord, this one is the main case and the other is the reference post. So these cases are little different. Their functions are similar, but their post designations are different. Their activities are different. They are engaged in different departments. They are in different sections. But in this case, in this particular case, my lord, the post is the same. Activities and the duties, responsibilities, skills required, everything is same. And they were already equalized in the rule itself. And thereafter a proper selection was held, and thereafter they were appointed to the post. Once they were already, my lord, their classification, whatever was done prior to their appointment was well founded, well justified, and they were equalized. Since they did not possess degree, they were to prove 15 years of experience in order to get the appointment. And in terms of skill, efficiency, and everything, nothing. Government side, they have filed their affidavit. Nothing has been mentioned. Had it been a case that some different, skill is required, or some special skill or special efficiency is required, in that case, they would have, taken that plea in their affidavit. Their affidavit is totally silent on this. Because in the series of judgment I'm referring to, given by the apex court, the proposition of law that is settled in those decisions were that when there is a little bit of chance of justifying a classification, and in that case, whatever classification is made by the authority concerned should not be disturbed. But where the justification itself is ill-founded totally, it's not supported by any substantive argument or reasoning. In such situation, my lord, discrimination to the writ petitioner or the aggrieved one is apparent on the face of the record. And in such a situation, what happens? If the aggrieved party comes before your lordship, the duty of this writ court to, look into this, intervene in the matter. On the last occasion, the advisory party relied upon one decision. Maybe I am mistaken, but here I have gone through the judgment also.
For the first time, this matter came to before this court.
Yes, yes. Yes, it was listed before some other coordinate bench. And in that case, my lord, this one judgment was relied upon my learned colleague. And yes, he has justified reason to, rely on that. But thing is that, my lord, that proposition or that particular ratio drawn by the apex court cannot be applied in a straitjacket manner in this particular case, because These are all context oriented.
So, no, that judgment is not available on the record.
Yes, that must be available, my learned friend probably.
Lordship, that was, I just saw the record, it was there, Lordship, I have a copy, Lordship.
Right.
2019, Lordship. Director of Education.
Yes,
Professor,
elementary.
Pramod Kumar Sahu.
Yes. And the relevant portion is
Lordship
that
can have there.
That is, yes.
relevant portion at paragraph 12, I guess.
Paragraph?
12. I rather support the argument advanced by the adversary. Yes, but that is applicable only when the posts are similar, functions are similar, or their responsibilities are similar. But when a situation is just the same, when the post is exactly the same, when the performance activities functions are exactly the same, holding the same post, and that too prior to absorbing them, there was a rule formulated, and in the rule itself there was a division, and they were equalized by imposing the condition of 15 years. So doing all this, and thereafter they were allowed to join, and they were given a single scale to both the classes of. All of a sudden in 2012, probably they were classified. Now the question is whether that classification carried out by the authority in the guise of bringing the new ROP is justified or not. If the classification is justified, my lord, in that case, my plea goes. I cannot succeed. And if I can satisfy this honorable court that justification is not required, uncalled for totally, in view of the imposition of condition of 15 years at the inception itself, and there is no skill required, no extra efficient skill or efficiency is required. So in absence of all this very valued criteria, how can justification be justified? Classification be justified? This classification itself is bad in law, therefore liable to be intervened.
You must show your decision. You have relied upon.
Yes, my lord, I am relying, first of all, I am relying on the same decision. Decision relied upon by my learned friend.
Okay.
Lordship may kindly come to paragraph 12.
Okay, we will resume after 5 minutes. We'll take a break.
Oh.
Yes.
Yes, my lord, paragraph 12 of the judgment relied upon by the respondent. That, shall I read the?
No, not necessary.
But here, the main thing is that they are relying on a judgment previously pronounced by the apex court, Sham Babu Barma versus Union of India. They are relying on, while passing this particular judgment, the honorable bench relied on paragraph 9, and the content of paragraph 9 is reproduced here. Nature of the work may be more or less same, but scale of pay may vary based on academic qualification and experience, which justifies classification. Now, Lordship may kindly read this line once more as to see the applicability of this particular judgment, the ratio in this particular judgment in our instant case. Here the works are different, the designations were different, nature were more or less similar, and court drawn a inference that yes, there may be reasonable classification on the basis of academic qualification as well as on experience. Now, your lordship may kindly take note of the facts that I already pointed out in my writ petition. These very facts has already been addressed to, has already been looked into and has been applied in our case. Academic qualifications, we admit that we did not have same academic qualification. By imposing the condition of experience, because experience plays a vital role in drawing reasonable classification, not only academic qualification. In the judgment itself, they say that experience also plays a vital role. in drawing classification, reasonable classification, if it is justified. In our case, by putting the condition of experience, 15 years of experience, we have already been equalized. It's settled that though we had not BE degree, diploma degree, we had 15 years of experience. And because of that, we are put at the same footing. And whenever an authority is to bring about some classification, then that classification itself should be justified by the authority as to why that classification was required. Submitting a caution and reliable argument for doing so, like efficiency is required. Suppose in today's context, in our case, can the authority say that the performance rendered by the writ petitioner is somewhat lower than the performance given by the other project engineers? Can at all such points be raised by the respondent authority? And my lord, I have already submitted for your lordship that they have not resorted to that kind of argument. They have admitted that yes, classification was done and based on qualification only, ignoring all other previous aspects, whatever was considered. This rule was made by them only. And on the basis of that rule only, advertisement was issued. On the basis of advertisement only, we applied. And on basis of our application, we were selected and we were inducted, we were appointed. And all these years we have spent, and all of a sudden they have brought about this classification totally unjustified. Totally unjustified. I have seen series of decisions, the apex. But this case is very peculiar, the instant case in hand. In the instant case, my lord, the post is the same. The post in question and the reference case. There are two posts. Normally what happens, a dispute arose with regards to one post and petitioner refers to other post. But posts are not identical, somewhat different. In this case, reference case is the same. I am also performing as the district project engineer, and the reference case post, the others, they are engaged in the same post. There is no difference between the subject post and the reference post. In other cases, all the decisions given by the apex court, the subject post is different and reference case is always different. This sort of dispute never arose and never decided also. When the subject post and the reference post is the same. And in support of our claim, we are relying on some decisions. So this may kindly be. Some decisions of this honorable court also. These are the various situations, my lord, where doctrine of equal pay for equal work was allowed. Actually, this doctrine was brought in the constitution in order to equalize the gender inequality. Now it has become an universal doctrine to be applied in a case of discrimination, be it on the point of gender or otherwise. And these are the cases wherein the apex court settled the law with regards to the application of doctrine of.
Okay.
So I have marked the relevant portion on. So your lordship will pass.
I will go through the same.
Yes.
Yeah, so Mr. Sovereign, what
Yes,
is your case?
please.
Lordship, I am straight away going to my affidavit in opposition. Lordship, paragraph 4. Lordship, I'm reading it over. That with regard to the statement made in paragraph number 7 and 8 of the writ petition, the deponent begs to state that in exercise of the power conferred by clause 17B, Roman 4 of the Memorandum of Association of Assam Harbour Hikka Obion Mission, the Executive Committee of SSA abolished the range of remuneration in case of engagement of district project engineer on contractual basis as per provision of the Assam Service Regulation, that is of Sorohika, and bifurcate the cadre of district project engineer into two separate categories on the basis of requisite qualification. The incumbent having BE civil degree are made equivalent to the assistant engineer serving in the PWD government of Assam. On the other hand, those incumbents having qualification below the BE civil degree, that is diploma holder in civil engineering, are made equivalent to the junior engineer senior grade of PWD government of Assam. This was done with a view to rationalize the post so as to commensurate with the two separate scales of pay prevailing in the PWD government of Assam. This is a step taken for furtherance of the spirit of equality as enshrined in Article 14 of the Constitution of India, and not to discriminate the petitioner and single them out for unequal treatment in preference to their colleagues similarly situated. Lordship, next paragraph, paragraph number 5, that with regard to the statement made in paragraph number 9 and 10 of the writ petition, the deponent begs to state that the authorities of SSA, in order to maintain parity in pay or salary structure of the employees under SSA Assam, the same was modified and the system of ROP-based fixed pay were brought in force. Lordship, the earlier range of remuneration that was completely abolished so that there is a parity between the salary taken by the employees of the government and the SSA, because SSA employees are either on contractual basis, deputation basis, or transfer or on transfer. There is no sanction post, Lordship. So earlier they were either receiving lump sum or some sort of higher pay, but that range of remuneration was completely abolished. Lordship, further, every post of SSS sanctioned under the Service Regulation and Fundamental Regulation 2003 of SSA Assam were identified to be equivalent to that of a post of state government. Lordship, all natures of posts that were made equivalent to the state government employees on the basis of qualification and natures of responsibility as indicated. In this regard, on due approval of Executive Committee SSA Assam, the restricting of salary was brought in force by notification dated 3/7/2012, issued under so and so by the respondent number 3. Under the above notification, on the basis of minimum requisite qualification, the post of district project engineer are categorized as follows. On the basis of the qualification, Lordship, these two criteria were taken into account. Now, Lordship may kindly turn over to the Annexure 1 of the affidavit in opposition. Lordship, it was issued in 2012. And the first line, Lordship will find the prevailing system of range of remuneration are referred in the SR and FR of SSA Assam is hereby abolished, and the system of ROP-based fixed pay will be enforced. It was decided by the Executive Council, that is the top apex body of the SSA. Lordship, they have decided to abolish the earlier range of system, and Lordship may kindly take into account the petitioner has not challenged this notification. It was published in 2012. They were silent. They were receiving the salary. Only in 2017, Lordship, another notification was issued when there was an increase in pay. That notification they have challenged. From 2012 to 2017, they remained silent, Lordship.
And Lordship, the purpose of making that classification on the basis of to make it equivalent with their respective education was based on, Lordship, the purpose was on the basis of the ROP, where the Lordship has seen it in the ROP. All pay scales are based in each and every post are based on the qualification in the cadre. And Lordship, the decision that I have relied upon, which earlier occasion before another coordinate bench, Lordship, I have produced, and Lordship has seen it. In this case, Lordship, the appellant was appointed as an untrained teacher on compassionate basis. Subsequently, Lordship, in Odisha, there was a change of the pay scale, whereby there was a trained and untrained was there. He subsequently, since he was at the initial appointment, he was having intermediate qualification. Subsequently, he acquired BA. He claimed for trained teachers pay scale, where the Lordship Apex Court, relying upon Shyam Verma's case in paragraph 12, Lordship Apex Court had directly said that the principle of equal pay for equal post should not be applied in a mechanical or casual manner. And in that case, Lordship, it was based on academic qualification or experience, which may be trained or untrained, Lordship. It was held to be valid. In the next paragraph, Lordship, paragraph 13, Lordship may kindly see, another decision was relied upon by the Apex Court. The said decision has been quoted by another bench of this court in Chhattisgarh Rural Agriculture Extension Officers Association versus State of MP in paragraph 22. Quote, Lordship, furthermore, as noticed herein before, a valid classification based on educational qualification for the purpose of grant of pay has been upheld by the constitution bench of this court in State of Mysore versus P. Narasingha Rao. Unquote, Lordship. Here, Lordship has seen in the memorandum of 2012, the purpose of making that classification only for the purpose of giving a rightful pay in consonance with the pay commission. That was the purpose, and for giving that pay scale and to achieve that object, Lordship, the classification has to be there on the basis of the academic qualification. It was not for only one post, it was for every post in the SSA. Lordship, another judgment I came upon few moments back, Lordship may tell it of 2023 15 SCC 257. Here also, Lordship, it was in the medical sector. Persons having bachelors of Ayurvedic medicine were claiming the similar benefit of MBBS holder. There was a committee, and committee recommendation, they wanted to have it. And Lordship, two issues were there. Lordship, first issue was whether different pay scale of pay can be fixed for officers appointed to the same cadre on the basis of education qualification possessed by them. Lordship, page 264. Paragraph number 24, Lordship. Two issues were there. In the first issue, Lordship, whether different scale of pay can be fixed for officers appointed to the same cadre on the basis of education qualification possessed by them. And second issue was whether allopathy doctors and doctors of engineers medicine can be said to be performing equal work so as to be entitled to equal pay. On the first issue, Lordship, Apex Court decided for the state holding that, Lordship, there can be a classification on the basis of
education qualification for the purpose of giving the pay scale. That is at page 267, paragraph 37. And Lordship reciting paragraph 37. All previous decision of the apex court on the same issue. Therefore, it is clear that the classification based upon education qualification is not violative of Article 14 and 16 of the Constitution. Hence, our answer to issue number 1 will be in favor of the state and against the respondent. Lordship, in sum and substance, Lordship, there can be a classification. Here, Lordship will see that on the basis of the OM of 2012, the intention of the SSA authority was to give them the ROP-based pay scale. And for that purpose, Lordship, the classification was done on the basis of education qualification.
My learned friend is done. Lordship may kindly permit me to just respond to his argument, whatever he has. My lord, he has just read one single line out of that judgment, that classification on the basis of academic qualification, reasonable classification made on account of, on the basis of education qualification is justified. I admit, but thing is that, in what context? Sometimes these educational qualifications, that point comes before appointment. And sometimes this may arise at a time when the question of pay scale is, revision of pay scale comes. In the instant case, my lord, the revision of pay scale has come. And in that particular situation, my lord, they have resorted to reasonable classifications on the basis of academic qualification only. They have totally ignored the qualification part that was there in the regulation, that was there in the advertisement, that was there in the appointment itself. They have totally ignored that 15 years of experience part. They have only taken into account the academic qualification part, and on the basis of that, my lord, this classification was then made, and they are now stating before this court, this honorable court, that this classification is reasonable one. Now, up to this honorable court to see whether the classification made by the authority is a reasonable one or not. Unless and until the classification is justified with reasons that why this classification was required. What was the necessity in the given context? Because our context is different. It is not with regards to admission to some school or engaging some doctors in hospital. Our case is totally different. Always case to case matter differs. Context differs. And in our present context, my lord, we are in a situation, we are two fronts. In the other side, some B degree holders are performing, and we are also performing. Sometimes we go to that post, they come to this post, and we perform in tandem. The whole department is functioning under us. There is not a single question of any dissatisfaction or any requirement of any specific skill or qualification or efficiency. And they have not argued this point. They ought to have argued this point before this honorable court, that yes, this classification was required, yes, necessary, as because these were the primary necessaries. Because in the Supreme Court judgment, there are many judgments. Supreme Court categorically held that if these elements are present, then only this reasonable classification is justified. Otherwise, two sets of persons, two sets of candidates, they have already been equalized by virtue of putting that extra condition of 15 years. They cannot be subjected to further detriment. It is a discrimination. if the classification is then not justified, that means what? The result is discrimination. They has not been treated equally. And if the department can satisfy this honorable court, yes, it was necessary and it was the mandate of law. Nowhere it has been submitted or argued that it is the mandate of law. It was the proposition of law given by the apex court that yes, this is the reason this classification was necessary. Because we also understand that yes, if somebody is higher qualified, they are otherwise eligible. But in our case, what happens? They are otherwise eligible, provided had there been no condition of 15 years of experience.
Okay.
Your Lordship has understood, I have submitted a lot and I have relied upon some decision. I could not even refer to each and every paragraph. Lordship will.
Lordship, only two factors. 2012, it was a policy decision. They remained silent. 2017, when there was a revision of pay, then only they came before this honorable court. Second point, Lordship has seen in the 2012 OM, it was only for giving the ROP based scale.
But that's all right. They've been working in the same department.
Same department, same post, Lordship
same
maybe
state
nature
thing.
and Lordship apex court has held that there can be similar nature of everything, but classification on the basis of the academic qualification, that is permissible, Lordship.
That's all right, but where is the weight of this
Lordship.
experience?
Lordship, everything that have, because the pay scale will be on the basis of that academic qualification and experience, Lordship. To commensurate with the ROP, Lordship, it has been done. But they were taking those, some may be getting a lower pay scale after the classification. They were receiving those salary and remaining silent. That explanation is not there.
Oh, that's all right, but
For 5 years, Lordship, 1 year also, that on my personal basis, I can concede. But 5 years, they remain silent.
that's all right, but whether after their appointment in the same court, then after implementation of this ROP, they are receiving the place amount of debt.
Yes, Lordship, on the basis of the classification that has been done, they were receiving that salary.
Less than the other part, their other counterpart.
Yes, no, counterpart, yes, Lordship, those having the VE degree holder, they will be receiving some a bit more than diploma holders will be receiving less. They were receiving till that they are receiving that salary, Lordship.
We remain, Lordship may kindly just permit. We remain deprived since 2012. We remain unaware for certain period. And thereafter it was came
That,
to our notice.
Lordship,
Lordship, again, I did not.
every employee getting salary per month, if he gets lesser, it immediately strikes them, Lordship. There cannot be any silence for 5 years, Lordship.
If it's permitted, I submit. Lordship, thereafter 2017 came, this was drawn. Immediately we filed this petition and it remained pending since 2015, 2017, awaiting a full-fledged hearing like this. Lordship will look into every aspect of it and will see.
In the judgment, you have relied upon the paragraphs are not part. You please part the paragraph again.
Pardon? And one more thing, my lord, similar anomaly was there in the accounts department. I have written that somewhere in my petition, in my affidavit. That has been mitigated. They have been equalized. Similar situation prevailed in the same department. SSC in accounts department, there was imperative, and that has been somehow addressed. That has been done.
Pardon, sir, pardon. Yes,
Question number 1, Lord.
I could conclude the judgment.
Upload.
My lord, in this matter, senior counsel K.N. Choudhury will appear, my lord. Can it be taken up at 2, my lord?
My lord, I am seeking a little, my lord, accommodation today, my lord.
Why?
So K. Gogoi will argue, my lord, Mr. K. Gogoi will argue, my lord. He is in another court, maybe today not possible. my lord.
At 2 o'clock. Hello.
And it is for the party control, it is for the after.
May it please the Lord, matter may be taken up after some time, Lordship. Senior counsel H.R. Choudhury is on lake in court number 16, Lord. After some time.
Sorry, at the time I was not present.
Now you tell me, can we refer the matter to the magistrate?
They want to go there, my lord. The Raspona 5 mostly under whom they were working, the garrison engineering. Let them oppose to authority.
Can we refer?
Because they are claiming the SCP scheme benefit. So that their family pension will be enhanced if the benefit is sent.
So when you will be able to appear there before mediator?
Next week, any day.
Next week.
After Puja, your lordship. Hello, pleasure, lord.
May it please your lordship. My lord, my friend Mr. M.K. Choudhury appeared for the petitioner, my lord. He has completed his part, so today is fixed for our reply. My lord, before I embark upon the reply, I'd just like to show one provision from the conduct rules, my lord. Sorry, UGC regulation. এখন দিও না। My lord will kindly come to page number 60.
Left side.
60. Towards bottom, professor. Has a lordship got it? Yes. Eligibility A or B. An eminent scholar having a PhD degree in concerned allied relevant discipline and published work of high quality, actively engaged in research with evidence of published work with a minimum of 10 research publications in the peer review or UGC listed journal and a total research score of 120 as per criteria given in Appendix 2, Table 2. Well, this eligibility criteria in respect of a person who is a faculty. So this is not applicable here. Now, lordship will kindly skip over to page 61. After the or an outstanding professional having a PhD degree in the relevant allied discipline from any academic institution not included in A above, industry who has made significant contribution to the knowledge in the concerned allied relevant discipline, supported by documentary evidence, provided he has 10 years of experience. The writ petitioner, my lord, prior to joining the university, he was not a faculty. He was, my lord, public relation officer of Northeast Frontier Railway. Therefore, in order to be eligible, what he must possess? He must have a PhD degree in the allied field, and he must have made significant contribution to the knowledge in the relevant field, my lord, supported by documentary evidence. Now, what had happened, my lord? The credential of the petitioner was screened by two experts appointed by the university. It was found, my lord, they were appointed by the then Vice Chancellor, who has since been, my lord, terminated from service. And those two, my lord, experts, they have also been blacklisted from the university. Now, my lord, to look into the legality and otherwise of the, my lord, one more, Janu. Sorry, my lord, there is one more aspect, my lord. If your lordship,
Those two experts
who have been blacklisted by the university,
prior to the selection of the petitioner or after the.
it was simultaneously everything was done, my lord. Simultaneously. My lord, when everything came to light, then what matter? My lord, apparently this gentleman, this writ petitioner, he doesn't have the eligibility. I'll show, my lord, because there was an inquiry committee and inquiry committee has held it. Now, one more thing, my lord, please come to page number 75 of the same book. Page number 75, heading is somewhere in the middle, selection procedure. Has your lordship got it, my lord? Selection procedure, then please skip over to the next page. Please come to Roman 5, page 76.
Yes.
In the case of selection of a faculty member who are from outside the academic field and are considered under clause 413B, the one I read of this regulation, the university's statutory body must lay down clear and transparent criteria and procedure so that only outstanding professionals who can contribute substantially to the university knowledge system are selected. So in order to select a person who is outside the academic field, then the university has to lay down the guidelines, my lord, as to how the merit or eligibility of such a person who is not a faculty is to be judged. Apparently, my lord, university has not prepared any guideline. The reasons are very obvious. University was oblivious of the fact that when we select a person other than a faculty, some difficulty may arise. Therefore, university must lay down the guideline. And I'll show from the inquiry report, my lord, there is none. So this is the background, my lord. Now please come to the inquiry report, which were annexed in the writ petition. So they have annexed in the writ petition, my lord. My lord will kindly come to page 47. Para 28 to the end. While going through the overall, as your lordships got it, Miller, while going through the overall process of selection, as well as the credentials mentioned in this application, the committee had also tried to explore if appointment of Dr. Jayanta Kumar Sharma was considered or could be considered in clause 4.13b of the UGC regulation of 2018. The UGC under the aforesaid clause has specified an outstanding professional having a PhD degree in the relevant allied applied discipline from any academic institution not mentioned in A above industry, who has made significant contribution to the knowledge of the knowledge in the concerned allied relevant discipline, supported by documentary evidence, provided he/she has 10 years of experience. In the instant case, this criteria has not been considered in the selection of Dr. Jayanto Kumar Sharma by the selection committee or by the university, as is evident from the minutes of the selection committee and records of the university. However, the two experts in their assessment report had mentioned for considering the application under this criteria. Although the assessment report in itself are faulty and not based on the overall criteria of UGC, the committee observed that application of Dr. Jayanto Kumar Sharma could not have been and cannot be considered under this criteria, since except having PhD degree, there is nothing on record to prove that he was an outstanding professional who has made significant contribution to the knowledge in the concerned allied relevant discipline. He had only one research paper to his credit, and there is no documentary evidence to support that he made significant contribution to knowledge in the area of mass communication. He was working as a PRO, and as a PRO, his job profile in the railway was different than the job profile of a researcher working in a research institute or a professional developing a policy document or bringing new invention or adding to the knowledge of the discipline. There is no evidence to prove that he had obtained any research project or developed any new research, teaching, learning, pedagogy, or produce any policy document, etc., so as to be considered as an outstanding professional. Moreover, the UGC White Clause 6.5, which I have read, my lord, has mentioned the criteria for selection of faculty members under 4.13b, according to which the statutory authority of the university must lay down and transparent criteria and procedures so that only outstanding professionals who can contribute substantially to the university knowledge system are selected. In the instant case, no such criteria or procedure has been laid down by the Krishnakanta Khandigoy State Open University, and accordingly, neither it could select Jayanto Kumar Sharma under the criteria for he has selected, nor it has selected him under this criteria. Conclusion. Based on the above observation, the committee is of the opinion that Dr. Jayanto Kumar Sharma did not fulfill the eligibility condition for appointment to the post of professor. The time of selection, committee also observes that there were deviations in the selection procedure and lack transparency, which require enough checks and balance so that such instances do not occur in future. The committee is thankful, etc., etc. So, my lord, this is the case. Now, naturally, he will be shy to face an inquiry. It's not difficult to seek, my lord. Situation is of such a nature, any person would be shy to face such an inquiry. Now, what had happened, my lord? Based on this inquiry and other procedural formalities, he was terminated. Then it was put to challenge. The learned single judge recorded everything, but learned single judge was of the view that no, if you want to get rid of him, hold an inquiry in accordance with the conduct rules. Now, my lord, against that order, we preferred a writ appeal. Now, in the writ appeal, this para is very important, my lord. End of the day, my lord, we are governed by the division bench order. The order starts at page 82. Now, please come to page 95. Para 21. In view of the above discussion, we have no hesitation in holding that learned single judge has not committed any illegality in setting aside the termination order issued by the registrar of so-and-so terminating the services of respondent writ petitioner as professor of Bhupen Hazarika School of Mass Communication and has rightly ordered for reinstatement of the respondent writ petitioner in service forthwith on the said post with all consequential benefit. Now, this is important. However, the appellant university can very well proceed against the respondent number 1 writ petitioner by providing him sufficient opportunity of hearing without adhering to the procedure laid down under the service rule of 29. So, end of the day, my lord, the division bench was of the view that we can proceed against him, and in doing so, we should comply with the rules of natural justice, but we need not conduct the proceeding as per the rules of 29. Now, which is what, my lord, my learned friend Mr. Chaudhary was arguing before your lordships. Now, my lord, kindly see appreciate one aspect of the matter, my lord. This is not a case where he is guilty of any misconduct which he has committed after he has been appointed. What we are saying is your entry into the service itself is illegal because you were not eligible. Now, that inquiry need not be necessarily under rules of 2019. In any case, my lord, even if there is any scope of debate, this order has attained finality. They have not carried it to Supreme Court, and SLP has been filed. Oh, SLP has been filed, my lord, but no stay order has been granted. Only a notice has been issued. Now, my lord, I would like to place 2-3 judgments of the Honorable Supreme Court how to deal with such a situation. When there is an allegation that somebody's entry into service is illegal, then to what extent the principles of natural justice apply? In fact, my lord, all the judgments were placed by us, which learned single judge in the judgment has already recorded. So instead of troubling your lordship with all the judgment, I'll just read 2.5 pages from the learned single judge's order, my lord. If your lordship will kindly come to page 76, which is part of the single judge's order. 76 of the writ petition. My lord, as far as the cases are concerned, these are all noted by the learned single judge at page 61, but I'll have your lordship's kind attention to page 76 from para 49. Page 76. Now, what is the view of the Supreme Court in such an issue? We are not alleging misconduct. All that we are saying is your appointment is illegal because you do not fulfill the eligibility. Therefore, it's not a case where he is charged with any misconduct for which a disciplinary action is called for. In case of Shyam Pardhi, page 76, Miller.
Got it.
In case of Shyam Pardhi, the Honorable Supreme Court on admitted facts of the case has held that since the prescribed qualification had not been satisfied, the initial selection is per se illegal. The question or violation of principles of natural justice does not arise. Then 50. In the case of Muhammad Satraz, that is, my lord, the Honorable, that is 2006 2 SCC 315, the Honorable Supreme Court has laid down that there can be a certain situation in which an order passed in violation of natural justice need not be set aside under Article 226 of the Constitution. For example, where no prejudice is caused to the person concerned, interference under Article 226 is not necessary. In Aligarh Muslim University versus Mansur Ali Khan, the Supreme Court considered the question whether on the facts of the case, the employee can invoke the principles of natural justice, and whether it is a case where even if notice had been given, result would have been different, and whether it could be said that no prejudice was caused to him, if on the admitted or proved fact, grant of opportunity would not make any difference. In MC Mehta versus Union of India exception laid down in SL Kapoor, KL Tripathi, where it has been laid down that not mere violation of natural justice, but de facto prejudice has to be proved. The court has also placed reliance in the matter of State Bank of India versus S.K. Sharma, where the principle has been laid down that there must have been some real prejudice to the complaint. There is no such thing as merely technical infringement of natural justice. My lord, I would like to pause here for a moment, my lord. When this principle was developed for the first time, the English judgment called Reeds versus Baldwin, where the English courts had said, my lord, the moment there is violation of natural justice, the order goes. Even in our Supreme Court, my lord, in Muhammad Ramzan Khan versus Union of India, took the same view. What had happened, my lord, after 42nd Amendment, the serving of second notice was dispensed with. Muhammad Ramzan Khan, who was a CRPF constable, my lord, he went to Supreme Court and he urged that since the inquiry report was not given to me, therefore it has caused serious prejudice, therefore my inquiry should go. And Supreme Court set aside. A subsequent bench of the Supreme Court, my lord, felt that Muhammad Ramzan Khan may not be a very good law. Therefore, the matter was referred. That is, my lord, that MD ECL versus Karunakar's case, where the Supreme Court for the first time said, my lord, in every case, if a notice is not given, it may not be fatal. It all depends upon the facts of each case. If there is a prejudice caused, yes. That means the delinquent will have to plead and establish prejudice, my lord. In which case, yes. Eventually, in State Bank of India versus S.K. Sharma's case, my lord, it has been authoritatively held in 1996 that no, it is only the test of prejudice which alone will prevail. Now, if we apply those tests to the facts of this present case, my lord, all that we are saying is we are holding an inquiry to find out whether you do have the eligibility. Can the petitioner filing writ petition prevent us from doing that, my lord, which he is attempting now? As an employer, am I not entitled to find out whether he has the proper qualification or not? There is no dispute that he is not a faculty member. He's a student of mass communication. He was a peer of NF Railway. Yes, I think in the year before he got the PhD, next year, my lord, he applied. That he is an outstanding professional, that he had made contribution which will further the cause of this husband. Where are the evidence? The inquiry revealed, once done, has revealed nothing. Therefore, my lord, it is in the fitness of things. Anyway, this Honorable Court Division Bench was of the view, disregarding the single judge's observations and findings, that you may proceed against him. While doing so, you must comply with the rules of natural justice, but you need not proceed under the rules of 2019. In other words, we need not hold a disciplinary proceeding because we are not charging him of any misconduct. We are questioning his very entry into the service. In such a situation, my lord, how the matter is to be dealt with. Precisely, my lord, Supreme Court has said in the 3 judgments I have read and the 2 judgments I will read further, will further clarify the position. Yes, my lord will kindly come to para 51 at page 77. The Honorable Supreme, I'm sorry, my lord, page 77. The Honorable Supreme Court has held in Ashok Kumar Sonkar, which are reproduced herein under. This brings us to the question as to whether the principles of natural justice were required to be complied with. There cannot be any doubt whatsoever that the odi alterum partem is one of the basic pillars of natural justice, which means no one should be condemned unheard. However, wherever possible, the principle of natural justice should be followed. Ordinarily, in a case of this nature, the same should be complied with. Visitor may, in a given situation, issue notice to the employee who would be affected by the ultimate order that may be passed. He may not be given an oral hearing, but he may be allowed to make a representation in writing. It is also, however, well settled that it cannot put any straitjacket formula. It may not be applied in a given case unless prejudice is shown. It is not necessary where it would be a futile exercise. A court of law does not insist on compliance of an useless formality. It will not issue any such direction where the result would remain the same in view of the fact situation prevailing or in terms of the legal consequences. Furthermore, in this case, the selection of the appellant was illegal. He was not qualified on the cutoff date. Being ineligible to be considered for appointment, it would be a futile exercise to give him an opportunity of being heard. Here, Supreme Court went to the extent of saying that since he was not eligible or qualified, you need not even extend him the courtesy of natural justice. It is not a case where appointment was irregular. If an appointment is irregular, the same can be regularized. The court may not take serious note of an irregularity in the meaning of the provisions of the Act. But if an appointment is illegal, it is nonest in the eye of law, which renders appointment to be a nullity. So if you do not possess the eligibility, then your appointment is a per se ab initio void. Therefore, there is no question of natural justice. Then, my lord, the Supreme Court in Mamta Mohanty has held as under. Para 37, it is a settled legal proposition that if an order is bad in its inception, it does not get sanctified at a later stage. A subsequent action development cannot validate an action which was not lawful at its inception, for the reason that illegality strikes at the root of the order. It would be beyond the competence of any authority to validate such an order. It would be ironic to permit a person to rely upon a law in violation of which he has obtained the benefit. If an order at the initial stage is bad in law, then all further proceedings consequent thereto would be non-existent and have to be necessarily set aside. A right in law exists only and only when it has a lawful origin. The concept of adverse possession of lien on the post or holding over are not applicable in service jurisdiction. Therefore, continuance of a person wrongly appointed on a post does not create any right in his favor. In Pramod Kumar versus so-and-so, this court examined the issue as to whether a person lacking eligibility can be appointed, and if so, whether such irregularity, legality can be cured, condoned. After considering the provisions of so-and-so, this court came to the conclusion that lacking eligibility as per rule, advertisement cannot be cured at any stage, and making appointment of such a person tantamounts to illegality and cannot be an irregularity and thus cannot be cured. A person lacking the eligibility cannot approach the court for the reason that he does not have a right which can be enforced through court. Then, my lord, paragraph 41. If essential educational qualification for recruitment to a post is not satisfied, ordinarily same cannot be condoned. Such an act cannot be ratified. An appointment which is contrary to the statutory rules would be void in law, and illegality cannot be regularized, particularly when statute is in no unmistakable terms says so. Only an irregularity can be. So, therefore, my lord, therefore, the preponderance of judicial view, in my humble submission, is, my lord, when the appointment is illegal, there is no question of, my lord, giving any legitimacy to it. Yes, you will be entitled to a notice, because certainly you will be entitled to a notice which we have issued. Now, in this background, my lord, what had happened? Kindly come to the writ petition, my lord. I'll read 3 paragraphs. Please come to para 21 at page 12. After the order of the division bench, my lord, what had happened? Kindly see. He has subjected himself to the jurisdiction. He has submitted already. That pursuant thereto, para 21 at page 12, The respondent university, I'm sorry, Miller. That person thereto respondent university-wide show cause letter dated 11/6/24 had directed the petitioner to furnish his explanation reply in response to an earlier show cause notice dated 3/4/23 within a period of 30 days from the date of receipt of the said letter. That the petitioner proceeded to submit his explanation reply on 10/4/7/24, stating his entire credential for the post of professor. In the interest of brevity, the petitioner craves leave of this honorable court to furnish a paper book of the reply. That pursuant to the reply of the petitioner was asked to appear for personal hearing on 9/8/24, while later dated 31/7/24. That on account of petitioner's son's health, the petitioner was constrained to apply for postponement of personal hearing, to which the respondent was pleased to agree by email dated 7/8/24. That so-and-so white letter had asked the petitioner to appear for the rescheduled personal hearing on 9/9/24 at 11 AM before the committee constituted for the purpose of examining the petitioner's reply to the show cause notice. Now, the aforesaid letter categorically states that concerned committee desires the petitioner to appear with all its original documents, including certificate, mark sheet, and other relevant document which the petitioner has enclosed with the original application at the time of applying for the post of so-and-so, so-and-so. That the committee, as aforesaid, to in the above twin communication have been constituted pursuant to resolution action. Now, my lord, is the university not entitled to go into the truth of the matter? Is it the case of the petitioner that because he has been confirmed, therefore a matter ends? My lord, in any case, my lord, the Supreme Court has in Union of India versus R.R. Verma has said that administrative authorities always have power of review. If they are denuded of this power, there will be chaos in the administration. My lord, an order may be passed bona fide because there was some misrepresentation. Subsequently transpires that no, this is bad, this was bad. Is the authority powerless, my lord, to inquire into the matter?
They have not challenged your power or
Yes.
authority.
Yes.
The question is that the inquiry was conducted behind your back, behind his back.
No, never.
No, he never participated in the.
Okay, now we are giving you a notice that inquiry, according to the okay, that, no, I am not relying on the earlier inquiry, my lord. I am only showing the facts. Now, my lord, we have issued a so-called notice after the division bench. Now, he has replied. Now, he was supposed to attend the personal hearing. Then he said that his son is seriously ill. We also gave him time. Therefore, he filed his writ petition. Kindly see the conduct.
That conduct is there.
No, my lord, end of the day, we are not saying that we will not inquire into. We will inquire into. If he has got any bias against the members of the committee, will change. If he has got any bias against any of the members, will change. Well, can it be a proposition that I as an employer, I cannot find out whether what he represented at the time of his application is right or wrong?
No. They have not questioned it.
Huh.
You
Then what is questioning? That is only what we are doing, my lord. We are doing only that because division bench has given us the right. And division bench order they have assailed, but no stay order is there. So, my lord, apparently he is not a faculty member. He was on the administrative side. Therefore, has he shown before your lordships that he has got 10 years of experience, that he is an outstanding professional? Has he? No, why?
No, the question is he was selected through a valid selection process.
No, my lord, that was not a valid selection process.
Maybe.
That selection process is bad because, my lord, the two experts who came to his rescue, both have been blacklisted by the university. And the vice chancellor who appointed him.
Subsequently.
Yes. Because of the activities like these, my lord. So, my lord, end of the day, we cannot be precluded from making an inquiry.
No, they were not.
Yes. Now, all that we want to do is only inquire into the, my lord, what we believe is not correct. Now, by virtue of the order of the single judge, my lord, he has been reinstated. Now he's working. Now, therefore, he has to satisfy the inquiry committee that he fulfills 4.3, he has labeled 4.3b, because he is not a faculty member. That he has to satisfy before the authority. That is 4.13b. And that is the mandate of the DB's order. And my lord, we have also shown that the rule 6.5, which provides that the guidelines should be laid down or criteria should be laid down for evaluating a person's eligibility. That is also not there, how it was done. So prima facie, my lord, he doesn't have the experience. He is not a person who has.
Right. But why the procedure was not followed? Why the inquiry was conducted behind his back?
No, that is gone, my lord. Now we are not conducting any inquiry behind his back. Earlier we did. That has been interfered by the court. The court has again given us liberty. My lord, actually, it was not behind his back, my lord. A committee of experts was appointed by the university to find out. At the end of the day, my lord, neither we nor lordships possesses any expertise. It is the field of the expert. 3 experts have said he has no experience. Anyway, my lord, because he was not associated in that process, he made an approach to this honorable court, and this honorable court said this is bad. And court has agreed with him. Now what is to be done? It has to be inquired into. Now we are inquiring into. He has come to the court. Now he should face the inquiry. Lordship will fix a time frame. Will conclude the inquiry and let him know what is his fate. And my lord, kindly see, this matter was heard. It was kept reserved, and no orders were passed. Anyway, those are we need not argue on those.
That is not to be looked at
Yes.
by this court.
Yes. So therefore, my lord, now we want to inquire. Now he himself says he has received a notice. He himself says he has replied. He himself says his son was ill on account of, therefore he prayed for time. Now therefore he should attend the inquiry now. And we are not saying that don't take part in the inquiry now. No, the decision is being taken behind his back. So in this view of the matter, my lord, I think lordships will close the petition, direct him to face the inquiry and fix a time frame. My lord will do it.
My lord, I have some reply to make.
Yeah.
My lord, for a moment takes up the UGC regulations, my lord. It was furnished before your lordship on a prior date, my lord. The UGC regulations, my lord.
My lord, can I just place one judgment, my lord, before my learned friend starts? If your lordship would kindly come to para 5, my lord, at page 406, 1983 SCC 402. It was again in the context of a my lord service matter. The last point raised by Sri Garg was that central government had no power to review its earlier order, as the rules do not vest the government with any such power. Sri Garg relied on certain decisions of this court in support of his submission, so and so. All the cases cited by Sri Garg are cases where government was exercising quasi-judicial power vested in them by statute. We do not think that principle that power to review must be conferred by statute, either specifically or by necessary implication, is applicable to a decision purely of an administrative nature. To extend the principle to pure administrative decision would indeed lead to upward and startling result. Surely any government must be free to alter its policy or its decision in administrative matters. If they are to carry on their daily administration, they cannot be hidebound by the rules and restrictions of judicial procedure, though of course they are bound to obey all statutory requirements, as also observe the principles of natural justice, where rights of the parties may be affected. Here again we emphasize that if the administrative decisions are reviewed, the decisions taken after review are subject to judicial review on all grounds on which an administrative decision may be questioned in a court. We see no force in this submission of the learned counsel. Now, well, two very distinct legal principles emerges from this passage, my lord. Number one, on administrative side, they are free to take in, they are not bound like by judicial or by quasi-judicial authorities, where power of review must be expressly provided. Secondly, it must be passed in consonance with the principles of natural justice, and the order which will be passed, that will be subject to judicial review. It's not that this order is final. This is always subject to judicial review on the grounds as can be challenged like any other administrative decision. So, my lord, we want to know that he had the eligibility. So this is the power, my lord. It will do. To keep point. My lord, there is one more division bench judgment, one paragraph, my lord. For the proposition, my lord, if the appointment is illegal, then a DP is not required. Para 25, 26 and 27, 29. In the case of Inderpreet Singh Kehlon, reported in so-and-so apex court as held, that when an appointment has been made, not in terms of the rules, but in view of commission of illegality in the selection process involved, same would be a void and a nullity, as it would be a violation of Article 14 and 16. In case of so-and-so, reported in so-and-so apex court as held, person who does not possess the requisite qualification cannot even apply for recruitment, for the reason that his appointment would be contrary to the statutory rules and would therefore be void in law. Apex court further held that lacking eligibility for the post cannot be cured at any stage, and appointing such a person would amount to serious illegality and not mere irregularity. Such a person cannot approach the court, etc., etc. Now, please come to paragraph 29, my lord. Though the facts of the case in Purushottam is slightly different from the facts of this case, there is a certain similarity, inasmuch as there has been usurpation of the vacant post by the void appointment of an ineligible person, which on the basis of the marks secured in the selection process should not have been filled up by so-and-so. The facts in the present case clearly show that it was due to fault of the respondent that so-and-so had been allowed to participate in the selection process. We are thus of the opinion that the right of Mrs. Kimbe Bobby to be selected for the post has been illegally taken away by way of a void appointment, and as such the right of Mrs. Kimbe Bobby under Article 14 and 16 has been violated. Now this is important. We are also of the view that if the appointment made is of an ineligible candidate, appointment being illegal and void was rightly terminated without any need of any departmental proceeding. So all that is required is he is entitled to a notice. Anyway, my lord, we are not going to that debate whether notice is required or not. We go by the view of the Honorable Apex Court in some of the cases. In some of the cases, Supreme Court says no, notice is not even required because it's an illegality. But no DP is required. And the division bench, my lord, at para 21, as I already read, my lord, has already said it. Therefore, they have to face the inquiry. That is my humble submission.
My lord, will kindly come to internal page 61 of the UGC regulation, my lord. This is clause B, 4.1.3B. If I may permit to read, my lord. Yes. An outstanding professional having a PhD degree in the relevant applied disciplines from any academic institutions not included in A above / industry, who has made significant contribution to the knowledge in the concerned allied relevant discipline supported by documentary evidence, provided she has 10 years experience. Now, my lord, this clause has two elements, my lord. One is the eligibility and the other is suitability. The eligibility is a PhD degree and 10 years of experience. The suitability, my lord, is that the individual has to be an outstanding professional and he has had to make significant contribution to the knowledge. Now, the reason I'm saying this, my lord, Lordship, I just submitted a copy of the judgment in Anna Matthews and others, my lord. Anna Matthews and others, my lord. This is not pertaining to the similar facts. There's just one observation of the Honorable Supreme Court in page number 664, paragraph number 3. Paragraph number 3. Paragraph number 3, my lord, page 664. So this matter pertained to elevation of an honorable judge, the High Court, but the issue has been clarified here, my lord. This court in so and so has held that appointment of a judge is an executive function of the President of India. Article 217(1) prescribes the constitutional requirement of consultation. Fitness of a person to be appointed as a judge of the High Court is evaluated in consultation process. Evaluation of the worth and merit of a person is matter entirely different from eligibility of a candidate for elevation, while Article 2172 prescribes the threshold limit or the entry point for a person to be qualified to be a judge of a High Court. Article 2171 prescribes the procedure to be followed, which procedure is designed to test the fitness of a person to be so appointed, so and so. Thus, this judgment draws on the basic difference between eligibility and suitability. Eligibility is an objective factor which is determined by applying the parameters or qualifications specified in Article 2172. Therefore, when eligibility is put in question, the question would fall within the scope of judicial review. However, the question whether a person is fit to be appointed as a judge essentially involves the aspect of suitability and stands excluded from the purview of judicial review. Now, my lord, assuming the petitioner did not have a PhD degree and assuming the petitioner did not have 10 years of experience, any amount of brilliance in his allied field would not have made him eligible. He could not have passed the initial threshold of eligibility, my lord. So the eligibility criteria in the UGC regulations is that the individual has to have a PhD and 10 years of experience. Besides, then and there is the incumbent to be assessed on his suitability for the post. Now, my lord, will kindly come to the last page of the writ petition, page 104. 104, my lord.
The expert.
This letter is dated 19/9/2022.
Page number
104, my lord, Annexure T. 19/9/2022. This is a letter, my lord, which has been preferred by the university. The eligibility criteria is the PhD awarded. Does the petitioner has a PhD? He has a PhD.
Graduation or mark vision.
My lord, the graduation marks can be lesser or more. That does not change the eligibility criteria. The second question is, does he have 10 years of experience? Your lordship will see work experience. 22 years in the Northeast Frontier Railway. So my question now, my lord, prima facie, on the basis of the facts which are there, does the petitioner fulfill the eligibility criteria? The answer is, my lord, based on records, he fulfills the eligibility criteria. Now, is the individual suitable, was found suitable pursuant to his recommendation? Your lordship would now kindly see at page 33, Annexure D, my lord. Page 33, Annexure D.
Yeah.
These are the two, my lord, recommendations of the expert. The experts did not select the individual. The experts were outside experts. They were based to assess the eligibility and the suitability of the individual. Thereafter, they said he may be called for interview. The selection was still the prerogative of the university until then. Now, my lord, will kindly come to page 35. Now, page 35, my lord, is the selection committee minutes, which has been signed by the then registrar who had terminated the petition. Your Lordship would see total 2 candidates were shortlisted and called for interview, out of which 2 candidates appeared in the interview. The committee, after taking into consideration of the academic credential, experience in ODL, research publications, and performance in the interview, unanimously decided to recommend the following candidates for appointment in order of preference. So the selection committee, which was a part of the university, had independently applied their mind based on the recommendation, because there were 2 individuals who were recommended, my lord. Out of which, after the interview was carried out, the selection committee, which is a part of the university, independently based on their assessment of the academic credentials, had selected the individual. Now, the person who was not appointed had not challenged the appointment of the petitioner. Now, my lord, we kindly see the prayer in this writ petition, my lord. Prayer number 1, my lord, is that a writ in the nature of certiorari should not be issued to respondent authorities to set aside and quash the committee constituted by resolution number so-and-so adopted in the 77th Board of Management. My lord, because the reason which has been stated in the petition is that the members of the selection committee who are going to scrutinize again afresh the petitioner's application are also a member of the Board of Management, and they'll be sitting over their own report. But that issue has been sidelined as of now, my lord. Your lordship will kindly come to the second prayer. A writ in the nature of certiorari should not be issued to the respondent authorities to set aside and quash the letter dated 21/8/2024 seeking to revisit the credentials of the petitioner. This is what we are aggrieved. Now, my lord, will kindly come. Before I take your lordship to the content of page 100, your lordship would kindly see page 21. Paragraph 21, my lord. Paragraph 21, my lord. My conduct has been assailed, my lord, in the petition. The show cause, my lord, at annexure N, 11/6/2024, which was furnished to me, my lord, pursuant to that, which I had proceeded to submit my reply. Then I was asked for a hearing on 31/7/2024, pursuant to which I preferred my email stating that my son is unwell. Thereafter, my lord, at annexure Q 21/8/2024 is the letter pursuant to which I was called again, which is at page 98. That is the second part of the prayer which you have sought for quashing, my lord. Apologize, my lord, page 100, 21/8. So my conduct cannot be assailed here, my lord, because only after furnishing of the letter dated 21/8 is when I approached the Honorable Court. Now, the reason for me approaching this Honorable Court, my lord, will kindly see the content of the letter 100 at page 100, my lord, 21/8/2024. The committee desires you to appear for the hearing with all the original documents, including certificates/mark sheets from HSLC to PhD, along with experience certificate, original PhD thesis, and other relevant documents, which you had enclosed with your application for the post of professor. So now they are seeking to revisit my suitability, my lord. My eligibility is not in question and not in doubt, my lord, as per their assessment at paragraph at page 103. I fulfill the eligibility criteria. Now they want to assess my suitability based on my thesis, my mark sheet. My lord, I am aggrieved by the fact that I'll have to undergo a subjective assessment of my post 5 years after I had been selected, appointed, and confirmed by the university. The eligibility is not the issue here, my lord. If the university decides to undertake and assess my eligibility, my lord, I would have had no issue or no occasion to approach this Honorable Court. The only reason I've approached this Honorable Court, my lord, is because they're seeking to revisit the entire subjective assessment of the petitioner 5 years after he had been confirmed. Now, there's an aspect which was raised that I was in close proximity with the Vice Chancellor at that point in time who have ensured my appointment. My lord, I was appointed during the tenure of one K. Das, Kondorpo Das, and I was confirmed during the tenure of Mr. N.N. Sarma. So he could not have had done that, my lord. If Kondorpo Das was the person who was responsible, as has been claimed, for my appointment, divorce the rules, I could not have been confirmed under the tenure of a separate vice chancellor. Now, the university had also initially, my lord, there was a letter which was furnished before this honorable court. Letter dated 17 February 2022.
Who had confirmed your service?
N.N. Sarma, he was in charge. The current VC is Rajendra Prasad. Yes, Rajendra Prasad. No. So there have been 4 VCs now. I was initially appointed during the tenure of Kondorpo Das, as confirmed during the tenure of N.N. Sarma. Now, my lord, you had seen by the letter that we had furnished before this honorable court on the earlier occasion, letter dated 7 February 2022, where it is stated by the same the registrar that as per the records available in the office of the registrar, the selection committee considered the suitability of the candidate in terms of the requirements and performance in the interview. Based on its recommendation and subsequent approval of the BOM, the offer of appointment was made. Now, my lord, there is no page. No, my lord, this was furnished before this honorable court, my lord.
Where?
On the earlier occasion, my lord, it was furnished before this court, my lord. 4 different pages, my lord, where Mr. S. Borua had taken back his complaint stating that it was not his. So that is a separate issue, my lord. But that is, I don't know.
Yeah.
Yes. Now, yes, my lord, my lord will see point number 3 in the first page. Now, this has been preferred by the same registrar who terminated my services. That as per the records available in the office of the registrar, the selection committee considered the suitability of the candidate in terms of the requirement and performance in the interview. Based on its recommendation and subsequent approval of the BOM, the offer of appointment was made. The university, now this communication was under a 3rd vice chancellor, my lord, the current vice chancellor, where the university had stated that my suitability was assessed. Now, my lord, there is no dispute to the wisdom of the honorable division bench of this court, where the university, my lord, was given the liberty to proceed against me. My grievance here, my lord, which has been stated in my submissions, is that the moment the university decides on my subjective assessment and terminates, it will open floodgates, my lord, for employers across the country to exercise discretion where subjectivity is a part of the selection. Let them check my eligibility, my lord. And it has been submitted before this honorable court in paragraph 22 that I have not submitted my credentials for the post of Bhupen Hazarika School of Mass Communication. In the interest of brevity, the petitioner craves leave of this honorable court to furnish the paper book.
Reply this on a reopening question.
No, to apna reply kita.
Multiple argument
No, suitability, eligibility. So this was the application which was forwarded, my lord, to the authorities at the time of his assessment. My lord will kindly see there is a flag mark, which is CV of the petitioner. CV. I'll just take your lordship through few pages, my lord, not a lot, few pages. Few pages. Your lordship sees PG of the CV of the petitioner, my lord.
Page number?
Page number 21, internal page 21, my lord. This was with the submitted to the university. I've had a flag mark also, my lord.
Yeah.
Yes. He started his professional career as a journalist in the Sentinel. Then he was an economic graduate from Delhi University. He was a PhD from the Faculty of Fine Arts, Guwahati University. He has a PG diploma in public relations, PG diploma in media law in Nalsar University, Hyderabad. Awarded twice for achievements in handling NF Railway public relations. My lord, these are page 21, page 22, page 23, page 24, page 25. These are some of the documents which were submitted by him at the time of his application. Now, my lord will kindly come to the preceding flag mark, my lord, which is at page 5. Page 5. Internal page 5. The uploaded documents. My lord, these are the documents which he had uploaded for the post for his appointment. Now, the issue which has been thought to be revisited, my lord, by the university is that they want to exercise their subjective assessment again on my suitability. Because my eligibility is always, as per the records, my lord, indicated I fulfill the eligibility criteria. And eligibility is an objective criteria. I have no dispute to the fact that the Honorable Division Bench has given them the liberty to conduct show cause and get for an explanation. But your lordship would see the content of the letter at page 100. They want to revisit my criteria. They want to assess my thesis. They want to see whether I'm fit by a committee, by a selection committee, which has been substituted subsequently. That was a separate selection committee, my lord. That committee is no longer there. Now, different individuals will be sitting in their place and will be assessing my suitability, not eligibility, my lord. Your lordship will see. My suitability will be seen. Now, if your lordship directs them to confine their roving inquiry on my eligibility, then I can have no dispute before this matter. But the fact I'm aggrieved is because, my lord, they have decided to exceed the mandate and go for a subjective fresh reassessment of my credibility, which is a subjective assessment. And the past conduct indicates, my lord, they've already made up their mind. It is apparent, my lord, I left my job in NF Railway, which I worked for 22 years. I get my PhD, I apply, I get called for an interview, I get appointed, I get confirmed. Now the university changes its stand. Now there is an SLP pending before the Honorable Supreme Court on the aspect of whether the service rules have to be adhered to or the show cause notice has to be adhered to. But the university wants to proceed with that. Now, my lord, I'll provide certain judgments, my lord. Yeah, read it.
I think, my lord, my learned friend is reopening the argument, then I must get a no. His idea was to reply to what I have argued. Now it seems he's coming up with fresh judgments. And I should also also get an opportunity because I would like to certainly reply on the judgment. Otherwise, my lord, it will be too much because yes, my learned friend has argued for one whole day, na? Final Sodhite ekbar argument korise already.
Yeah, yes, yeah, to be there.
Judgment দেখো নতুনকে দেখাবো
My lord, your lordship will kindly come to paragraph number 6. Which is at page 296, my lord. The question which is to be answered is as to whether in the process of shortlisting, the commission has altered or substituted the criteria or the eligibility of a candidate to be considered for being appointed against the post of a presiding officer, Labour Code. It may be mentioned at the outset that whenever applications are invited for recruitment to different posts, certain basic qualifications and criteria are fixed, and the applicant must possess those basic qualifications and criteria before their applications can be entertained for consideration. The selection board of the commission has to decide as to what procedure is to be followed for selecting the best candidates from amongst the applicants. In most of the services, screening test or written test have been introduced to limit the number of candidates who have to be called for interview. Such screening test or written test have to be provided in the concerned statute or prospectus which govern the selection of the candidates. But where selection is to be made only on the basis of interview, in this case, my lord, there is an eligibility and thereafter interview. The commission or the selection board can adopt any rational procedure to fix the number of candidates who should be called for interview. Now, my lord, I'll be brief, my lord, since my lord will kindly come to paragraph number, to page 28. Page 28 of the writ petition, my lord. Page 28. Page 28. The manner of appointment, the university shall advertise the post with which such qualifications have been prescribed in the ordinance. My lord. Yes. Yes. Yes, my lord. Because this is their document. This is their document. I was an outsider. I was a beneficiary of the selection process. I was an outsider. Now, your lordship, affidavit in opposition. In affidavit in opposition that they have filed. Reverting to this submission, my lord, their submission is that with regard to the statements made in paragraph number 6, which we are concerned with 6, while putting the petitioner to the strict proof thereof and reiterating the statements made herein above, the deponent humbly states that petitioner's candidature is not as per the provisions of the existing relevant laws of the land, including the KKHSOU Act 2005 and the ordinances framed thereunder, as well as the UGC regulations of 2018. So if they can show, my lord, under which provision the appointments are usually made, then may clarify the matter, because they have not disputed our contention. My appointment was as per the rules. My appointment was as per the UGC regulations where I fulfilled the eligibility criteria. I was appointed. I was confirmed. Now there is no dispute to the wisdom of the division bench of the Honorable Court. What I seek to pray and assail, my lord, by way of this petition is that firstly, the committee members which have been entrusted to look into my qualification need to be substituted. Firstly, to not include members of the Board of Management, but that is the first case. The second prayer which has been stated, my lord, which is more important, my lord, is that they cannot exceed onto the suitability and the subjective assessment of the petitioner. If they can confine their assessment of my suitability and eligibility based as per the eligibility criteria, then, my lord, I'll be ensured that I'll have a job in place. Otherwise, my lord, they will take my. They've already made that done. That is my submission, my lord.
I'll just take 10 minutes, Miller.
Okay.
Lord, basically, my learned friend, I didn't have the advantage of listening to this argument when Mr. Minal Chaudhary opened up. That's why I'm standing up to give reply to that. Lord, his basic case is, there are two aspects. One is eligibility, other is suitability. Now, my learned friend is trying to draw analogy between selection of a High Court judge and a Milord, what do you call it? A professor of an university. And the Supreme Court itself says, Milord, this whole system is opaque. Therefore, Milord, I do not know how an analogy can be drawn from a selection of a High Court judge procedure with the professor. Having said that, my lord, let us test my learned friend's argument. Now, he says, eligibility can be adjudged by objective criteria standard. Very correct. Now, when it comes to, my lord, adjudging the suitability, then it falls in the realm of subjective satisfaction. Am I clear, my lord? But my learned friend has failed to notice one thing, which Supreme Court has again and again said. This subjective satisfaction must be derived from objective materials. This subjective satisfaction should be derived from objective materials. Now, my lord, let us see whether those objective materials were there before the earlier committee to, my lord, record a finding that he is eligible. Now, please come to the, my lord, that rules which I, UGC regulation which I have given once. Just one minute, my lord. B. Yes, page number 61. An outstanding professional having PhD degree, which he has, he was appointed in 2020, he obtained the PhD in 2019. From any academic institution / industry. Now this is, who has made significant contribution to the knowledge in the concerned allied relevant discipline, supported by documentary evidence. Now, where is that? Now, please come to 104. That is his sheet anchor, my lord. Please come to page 104. His case. That's why, my lord, what is very important is the subjective satisfaction could be subjective, but it must be based on objective material. Now, where is, my lord, experience? Work experience is different thing. How you have contributed to the subject? Where are the publications? Where is it, my lord? Kindly see number of publication 1. That already the earlier inquiry committee has taken note of. Research guidance 6 already is guiding research students. Work experience 22 years. Year of PhD 2019. Marks in graduation 48.62. Normally, my lord, on academic line, my lord, I have not come across anybody with 48.62, my lord. Lesser mark. Anyway, it doesn't make any difference. Now, question is, which is that objective material going by his case, my lord? If this was before the selection committee, then how the selection committee adjusts his suitability in the absence of experience? Now kindly come to the inquiry report once, my lord. Just 1 minute, my lord. Please come to page 47. After, my lord, quoting that B, 41B, in the instant case, criteria has not been considered in the selector of Dr. Jayanto Kumar Sharma by the selection committee by the university, page 47, my lord. As, yes, but somewhere in the middle, after that outstanding part, next para. In the instant case, the criteria has not been considered in selection of Jayanto Kumar Sharma by the selection committee or by the university, as is evident from the minutes of the selection committee. In the minutes of the selection committee, there is no experience certificate because he don't have. Even he have not annexed to the writ petition also to demonstrate that he has got that, Miller. He could have. He did not, because how can he give? Because he doesn't have. However, the two experts in their assessment report had mentioned for considering the application under this criteria. Although the assessment report in itself are faulty and not based on verifiable criteria of UGC, the committee observes that the applicant John Sharma would not have been and cannot be considered under the criteria, since except having PhD degree, there is nothing on record to prove that he was an outstanding professional who has made significant contribution to the knowledge. So my learned friend is absolutely correct when he says eligibility can be judged by objective materials. Absolutely. And when it comes to arriving at a subjective conclusion, it is subjective, but it must be based on objective material. Now, which is that objective material regarding his, my lord, contribution? Which is that objective material regarding his experience? Because the criteria says, it uses the expression supported by documentary evidence. There is none. So therefore, my lord, the judgment, when it comes to appointment of an High Court judge and at the level of Collegium of the Honorable Supreme Court, when this suitability is judged, but is it justiciable, my lord? But here it is. So therefore, to draw an analogy from their judgment is not correct, one. And secondly, my lord, that objective materials were not there to arrive at this subjective satisfaction. It is always said, my lord. NSA detention, my lord. When a person is detained under NSA, the district magistrate arrives at a subjective satisfaction. But the file must contain objective materials. In this case, the objective material is where are his experience certificates. Other than the PhD certificate, there is nothing. So, my lord, by his own showing, I am not even trying to show anything else. Therefore, my lord, my humble submission is, it's a fit case where we should be permitted to take the case to the logical end. And, my lord, as Supreme Court said in R.R. Verma's case, the authority has the power of review and authority will review. And that would be subject to judicial review. Tomorrow, after passing of an order, supposing, my lord, the order goes in his favor, matter ends. Supposing the order goes against him, then, my lord, if he can satisfy your lordships in a subsequent attempt that this exercise is bad, then lordships will always interfere. So therefore, to say that, and my lord, the page 100 does not speak of any subjective. That my learned friend has uttered quite several times, but I have not seen that word subjective, my lord. That they would like to draw an analogy. Please come to 100 for a moment, my lord. He was reading. He was trying to draw that word from this. I couldn't find. The committee desires you to appear for hearing with all the original documents, including certificate, mark sheets from HSLC to, sorry, page 100, my lord. From this, he was trying to draw an analogy that we are going to, again make a subjective examination of his credentials or to revisit. Now, the second sentence, my lord, the committee desires you to appear for hearing with all original documents, including certificate, mark sheets from HSLC to PhD, along with experience certificate, original PhD thesis, and other relevant documents, which you had enclosed with your application for the post. the committee has also decided that video recording of the hearing will be done. So everything will be in black and white. He wants to prevent this because he doesn't have experience. So that is my humble submission, my lord. So that judgment, though it lays down a law, but in the context of a selection of an high court judge, I don't think, my lord, that will have any application. Even if it has application, my lord, there is an inherent, flaw in the approach, because end of the day, the subjective satisfaction has to be derived from objective materials. It can be in vacuum. That is my humble submission.
But,
What do you want?
I'm sort of trying to- Yeah. So, yeah.
Deep law.
I'm grateful, my lord. My lord, the documents have been uploaded on 2020, my lord. I've just highlighted for your perusal. Yes, my documentary evidence was already there.
I think 25 and 26.
Records. My lord, the records was called for and it is available with my learned friend, my lord. My lord, this is the case and wherein, my lord, we were supposed to be regularized pursuant to that, my lord, cabinet memorandum. Now, my lord, although some of the persons has been regularized, we were left out. And then again, an inquiry had been directed, my lord. And in that inquiry, an impugned communication has been made that we were unauthorized absent, my lord. Therefore, we are not equally situated with the other batch of persons, my lord, who were recommended by the cabinet. In fact, my lord, in the cabinet memorandum and the subsequent notifications, my lord, our names were there. But at the time of regularization or the fixed pay, my lord, we had been dropped. Just for a moment, my lord, I beg to draw my lordship's attention, my lord, to the cabinet memorandum, which is at page 35, annexure 2, my lord. This is a memorandum, my lord, is required to be circulated under the Rule 17 of the Assam Rules of Executive Business. Payment of fixed pay at the rate of rupees 15,500 per month to the 52 graduate teachers of the different higher secondary and high schools of Nagaon and Sonitpur district. During the year 2001, for filling up the vacancies in schools all over the state, the government in the secondary education department issued instruction to the inspector of schools via WT message number so-and-so, dated so-and-so, for carrying out the appointment of the graduate teachers in the vacant post. But subsequently, it came to the notice of the government that the concerned inspector of school in some districts appointed teachers in excess over the vacancies as allowed to be filled up. While the aforesaid government instructions for the various reasons, the teachers recruited in excess were not terminated from their services and they continued to work. In compliance of the order passed in WPC 544/2001, the government issued another instructions to pay these teachers who were recruited without keeping parity with the approved vacancies a lump sum fixed pay of rupees 2,500 per month, and also allowed them to continue in service till termination from service or regularization of service. The fixed pay of rupees 2,500 has been enhanced to 15,500 by notification number so and so. The following is the position of the such teachers appointed in the different districts who are now getting fixed pay of rupees 15,500 per month. My lord, we are only concerned with the Nagaon district, wherein, my lord, it is 244 numbers of teachers. But some teachers who were also appointed in the excess over the vacancies at that point of time were left from getting.
Sir, Bhuya, on the other day, you have shown this document to me.
My lord,
You have shown this document to.
Yes, my lordship has already, gone through, my lord.
Repeating it.
Yes, my lord, and therefore, my lord, now my lordship has once initially directed the department to produce the records, my lord. That whether and under what circumstances we were left out. My lord, our case is very simple, my lord, that as we are, my lord, similarly situated with the other persons, and the cabinet has also directed for our regularization to bring at par with the other teachers, my lord. So therefore, my lord, the impugn speaking order which has been issued by the Millard department, which is at the last of this Millard petition, is Millard non-est in law, because this is an attempt by which Millard the department is now, the executive is now trying to override the cabinet memorandum, Millard. That is the Millard, Millard, the crux of our case, Millard, which they cannot, Millard. Lord, I have prepared a compendium of the judgments. 3 judgments is so voluminous, my lord. I have, my lord, has given for the binding, my lord, and I will submit before my lord, my lord.
When?
By tomorrow, my lord, I can submit it.
Yes, Mr. Gupta, you have received the.
My lord, I've received the record, my lord. Here, my lord. WPC 935, my lord. The prayer in this repetition is to, my lord. Though the word regularization has been used, but the relief which has been sought in the repetition is setting aside the speaking order dated 2/12/2022 and directing the respondent to comply with the cabinet approval which had been circulated under Rule 17 for the purpose of extending fixed pay to the petitioners. Now, my lord, your lordship will kindly see though the petitioners has tried to made out a case that a cabinet approval has been given and the executive has deferred from the cabinet approval, the cabinet memorandum. That's not what. The speaking order at page 62 will clarify, my lord.
Yes.
May I just read, my lord, page 62?
Hmm.
The findings during the year 2001 for filling up the vacancies in the school all over the state, the government in the secondary education department issued instruction to the inspector of school by WT dated 26/03/2001 for carrying out appointments of graduate teachers in the vacant post. But subsequently, it came to the notice of the government that the concerned inspector of school in some districts appointed teachers in excess over the vacancies was permitted to be filled up. As per the report of the Director of Secondary Education, 15/11/2011, number of the sanctioned posts under the Nagaon district were 71 numbers, but the teachers recruited against the vacancies of 297 numbers. Out of 297 teachers, 240 were working against sanctioned posts and 45 were against non-sanctioned posts. 244 numbers of teachers under the Nagaon district were getting fixed pay of rupees 2,500 per month since the year 2001, and later in the year 2015, fixed pay was enhanced to 15,500 with the cabinet approval in respect of 244 fixed pay teachers. In the year 2020, matter was moved for cabinet in approval of respect of 45 numbers of Nagaon district and 7 numbers of Sonitpur district for allowing fixed pay of rupees 15,500. The Honorable Cabinet had approved the same in its meeting held on 18/4/2020. Now, the petitioners belongs to this 45, group of 45. As accordingly, the notification was issued in respect of 37 numbers of teachers of Nagaon. As regards, this is important. As regards 8 teachers of Nagaon district, it has been found that these teachers have ceased to be working for various reasons as reported by the Inspector of Schools Nagaon. Since the benefit have been proposed with prospective effects and they are not in service at that time, such 8 teachers have been dropped from the list of 45 numbers of teachers. The present 5 teachers among the earlier list 8 teachers who were not considered. Thereafter 5 teachers, namely Puravi Bothakur, Parama Pora, Hemanto Kumar Borua, Sahabuddin Ahmed, Sabina Yasmin, prayer petition before the government for allowing them to draw fixed pay of rupees 15,500. Well, these are the petitioners before your lordship. There are 3 reports from dated 11/5/2017, 12/1/2021,
N28/2021 from the Deputy Commissioner, which clearly indicates that they were not in continuous service from 2001. Deputy Commissioner's report dated 11/5/2017 was more clear in this regard. In this regard, the Office of the Deputy Commissioner had furnished inquiry report by letter dated 18/5/2020 and letter dated 12/11/2021. The earlier report of the Deputy Commissioner dated 11/5/2017 and the recent report as mentioned above are contradictory. In this regard, in respect of the above the said teachers, hearing was conducted in presence of the inspector of school and the concerned headmaster principal of their respective school, and the attendance register and other documents were verified. Records indicate that they were not continuously serving, irregular, and were absent without any record of authorization for a long time. Now, these 5 teachers paid before the government for a regular scale of pay at par with dated 26/2/2021, which allowed the graduate scale of pay in respect of 264 numbers of fixed pay teachers under Nagaon district with approval of the cabinet. Considering the report of the Director of Secondary Education dated so and so, these 5 teachers don't fall under the criteria laid down, then the fixed pay teachers who are now getting the benefits of ROP as per the government approval. Decision. In view of the above facts and circumstances and verifying the reports of the Deputy Commissioner Nagaon, hereby rejects the claim of the petitioner for granting the benefit of scale of pay and regularize the service in view of the unauthorized absence from their duty. So, my lord, after the cabinet has approved for these 45 numbers of teachers, my lord, I have the record, the entire record of all those 37 teachers. Our exercise was done by the government to verify as to whether with regard to their working status. And after being satisfied that they are working, these 37 number teachers were given the benefit. Because the cabinet approval was to give them fixed pay in a prospective manner, not for arrear. So the fixed to grant them that benefit, they will have to be working at that point of time. And these 5 teachers, my lord, the inspector called all the petitioners, my lord, for a hearing. And during that hearing, my lord, I have got this report. And the report, my lord, of this teacher, the headmasters of these schools who have certified that they, since 2001 to some particular time, these teachers were working and thereafter they have stopped coming to the school. And my lord, as the petitioners are praying for a writ of certiorari for setting aside this speaking order, my lord, there is nothing on record in the writ petition, my lord, to show that the findings of the secretary in the speaking order is not correct. In fact, there is no challenge in the writ petition also with regard to the decision-making process, my lord. If I may draw your lordship's attention to page 61 for me. Page 60, page 61. My lord, these are, my lord, based on the hearing that has been taken by the department, my lord, along with the inspectors and the other petitioners, my lord, this speaking order referred. And my lord, this is the record, my lord, if your lordship want to peruse, my lord. Your lordship will find the the certificates of the headmasters of the school, my lord, which starts from page 30 of the record.
So, what were the criteria in the cabinet memorandum for regularization of service?
Well, the the cabinet did not took a resolution for regularization, my lord. Whereas, if your lordship will kindly see, may I just point, draw your lordship's attention to page 36, my lord.
Hmm.
The reason for taking the decision, my lord, by the cabinet. Paragraph 4.
Yes.
But some teachers who were also appointed in excess over the vacancies at the point of time were left from getting fixed pay. And these 45 teachers, well, these some teachers means the earlier 244, there was a cabinet decision taken in respect of 244 numbers of teachers. This cabinet is only in respect of 45 numbers of teachers. And these 45 teachers in Nagaon district and 7 teachers in Sonitpur district are still working but not getting any fixed pay since their appointment. Considering the entire matter, the department took step and called for a working status report from the Deputy Commissioner and the Inspector of Schools, Nagaon and Sonitpur district. And accordingly, the Deputy Commissioner and Inspector of Schools had submitted a detailed report stating that these teachers in Nagaon and Sonitpur are working without receiving any fixed pay since joining. The Inspector of School Nagaon had also identified equal number of vacant posts for the adjustment. After careful consideration of all aspects, it has been proposed to examine the matter actively to bring it logical conclusion as follows. On examination of record, it is observed that there is a disparity in the principles of payment of fixed pay. While one set of teachers in the same platform and circumstances numbering 244 in Nagaon district are being paid fixed pay, and other set of similarly placed teachers numbering 45 in the same district are not being paid the fixed pay. Similarly, in Sonitpur,
Cabinet memorandum was prepared on 4/12/2018.
my lord,
And when the inquiry was conducted?
this, my lord, the 37 thereafter, at least in 2020, 24 June 2020, this cabinet decision was given effect by a notification of 24 June 2020, page 47. In respect of 37 numbers out of the 45.
Okay. And when the inquiry was conducted?
Inquiry is in 2022. The record which I have placed, that is page, that is 2022. This is pursuant to their representation when they have claimed and that we were among the 45 and we were left. Thereafter, this hearing had taken place and the result of the hearing is the speaking order.
No, you told me the inquiry report coming by the Deputy Commissioner. No.
I'll flag my.
As per this speaking order, there are three reports.
Well,
One is the report of the inspector of school dated 18/5/2020.
original report.
And the other two are the inquiry report submitted by Deputy Commissioner Nagaon on 12/1/2021 and
11/5/2020.
Next case petition, the inquiry report, the substance of inquiry report is the next petition. In my petition,
all the three inquiry report.
in my petition, I have annexed the all document along with the report. In next case.
I am concerned with the inquiry report mentioned in the Tribune order.
Yes, that is right. Oh, okay. Lordship. Yes. Lordship, kindly take the 4110. Next, please.
Yes.
Dear Lordship find in Lordship will question about the record of the Deputy Commissioner. Lordship, kindly have a look on the Annexure 7, page 35. Page 35.
Yes.
Lordship got it, page 35. There is order communication dated 27/1/2021. And this record was earlier called by this court in my case. With reference to the above cited, I have the honor to submit here with an inquiry report submitted by the Inspector of School Nagaon and Assistant Teacher Commissioner Nagaon in respect of 5 unpaid fixed pay teacher as follows. These are my name is Lordship will find serial number 5. And I also indicated this communication is issued, Lordship can say reference to their letter on 31st August 2020. Lordship, in the reference, Lordship find that your letter or your order dated August 2020. And now And this was the report submitted before the respondent authority. Now, Lordship will kind to, for a moment, Lordship will kind, so that it will be lesser time to understanding the impugn speaking order. Next,
Mr.
next page.
Borua, Mr. Borua, there is no reference of this inquiry report in the impugn order.
Yes, this inquiry report is referred in the speaking order.
Where?
Okay, Lordship will find. That this order in there paragraph Lordship will find page 35. There are three report dated. There are three report. Three report. Page number 38. Lordship will in speaking order. Lordship. There are three report. Lordship will find paragraph 38. Paragraph 1, 2, 3, 4, 5. Fifth paragraph from the order. Lordship, better Lordship, I'll take the inquiry report. It will better to I'll show the someone which next year will their, and they also accept in their affidavit. Yes. Lordship, first take up this speaking order.
Whether it is annexer 7, page 35, is mentioned in the.
Is the communication of the speak order communication to the respondent authority by the deputy commissioner regarding report, and in enclosed Lordship will find at stated total 24 seats. Lordship will find. And there Lordship will that chart Lordship will find. First Lordship said name of the teacher, school name, inspector school report, executive magistrate report, and this is the document sent to them, and that it will, and that will only Lordship further clear in next page. Lordship will go to the next page. It is the next page. Lordship. The deputy commissioner with reference to what you find next annexer 8. It will further clear about the matter. Page 36.
Yes.
With reference to the subject above, I have honor to inform you that report submitted by this office 28 to 21, that is those indicated the speaking order, possible speaking order, also read is T, serial number T, in speaking order. Page 37, serial number T, Office Deputy Commissioner Inquiry Report, that is 2821. In speaking to page 37, Lordship. And now, here it is speculated with reference to the subject above. I have honor to inform you that report submitted by this office on 28/21 by letter dated so and so in respect of 5 of teacher unpaid fees passenger under Nagaon districts may be treated as partial modification of our earlier letter number so and so dated 11/5/2017. That is also indicated in the speaking order. Further, as reported by the inquiry magistrate, I would like to inform that present the said teachers are continuously serving in the respective school. And earlier, Lordship find this letter, what I indicated, the Lordship will kindly noted that 31st August 2020, they have issued a order to the deputy commissioner to inquire the matter. The who are the working, whether these are working, and this was given after issuing the regulation of order of the 37. 37 discharge was issued on 24/06/2020. 37 discharge regulation order has been given. Speaking of the issue reflect 24/6/2020. As we are left out, we are opposed. Immediately after they have issued this order to the deputy commissioner, and deputy commissioner, after due inquiry, they placed the report. And now my learned friends says that to challenging the impugned order, what is the error? I say, will you kindly have a time with me? I will show the each paragraph, which are the perverse, which are the contrary to the report, because to say that the order lordship, I have to show you lordship that the inquiry is erroneous. This speaking order is erroneous. To giving this erroneous order, I have to satisfy your lordship that whether the statement consideration taken by the authority is perverse, whether is not in accordance with the law. Therefore, lordship, I want to take the inquiry, the speaking order, and taking with the speaking order, already my friend sent the factual part to speaking order. I will, in my petition, I annex the all document. I will satisfy your lordship that this, so far my petitioner is concerned, with document of the inspector, if document of the headmaster, with document of the deputy commissioner, document from the magistrate inquiry, I am continuously work. Save and accept. I am clearly noted. Save and option 4 months, no? 4 months I had during my whole career, 4 months I am absent with permission, leave permission for some maternity reason, which is admissible. Now there is no unauthorized absence from my part. There is no non-continuation in my part. Lordship will kindly take the.
Sir, Kaushik, you see, annexer 36, the annexer 8, page number 36, correct? 4110 of 2020.
Oh.
That is also one of the report of the deputy commissioner. And it indicates that the teachers are continuously serving in their respective schools.
Yes, in fact, the inquiry report which I have submitted, my lord, in respect of this petitioner, it has been said that only for 4 months she was not there.
Yes. Then
In respect
why
of
I
this
should
petitioner. But rest of the petitioners, my lord, the other petition, my lord,
So,
there are certificates.
This petition. So the finding recorded in the impugned order appears to be arbitrary
According, as per the records, my lord.
as per the record.
As per the records, because this inquiry report says, my lord, in fact, the working certificate of this school headmasters also, in respect of the petitioner, Sabina Yasmin, it has been said that she has been continuing in service since 2001, but from March to September, she was not present in the school.
Not present due to that application also I have annexed. That is
Page number?
that reason for the
Page number.
page number, lordship. Page 25, lordship, that is my application to the headmaster. And that is supported by lordship page 42, the certificate of headmaster, working certificate of headmaster. I am giving all document, nothing to hide. I only 4 month. What do you mean? And should I taking into consideration the unauthorized?
No, Mr. Borua. Page number 42 is not here.
Annex 10, my lord. Annex 10, page 42. In the read petition. In my read petition.
That is page number 39.
It's 40. In my area, it is 42. The last annex 10.
Okay.
It would be 42 only.
42.
Yes,
think it was-
Mr. Kochek,
My lord.
this annexer 8
Well.
of page number 36. Number
My lord.
4:0. There also mentioned about other petitioner. 5 number of
Second.
unpaid paid research.
No,
They are
that's,
continuously serving in their respective school.
my lord, but that is contrary to what the working certificate has been given by their school headmasters. Sir. The originals are here, my lord.
Oh, take it if whether I am working or not.
In respect of this petitioner, the headmaster has certified that she is working, and for 4 months she was not there for some matter. It has been said that for some personal reasons.
So that's all right, but
Oh,
in respect.
But in
of
respect of the
other-
other teachers, my lord, this finding is contrary to the records, my lord.
Then
Record speaks that they were not there. Some teacher, like in respect of Hemanto Borua, that
whether in passing the impugned order, this letter was taken into account.
no, my lord, this is the file, my lord, of the hearing. This file contains, my lord, these working certificates.
So I am asking you whether this letter was taken into account while passing the impugned order.
Page 36.
Yes.
The speaking order doesn't refer to, my lord.
Referred to.
That doesn't refer to.
And whether you have dealt with in your affidavit opposition with this annexer?
No.
No.
In the affidavit, we have taken a stand that as from the report in the hearing, it has been found that these teachers were not working, and therefore on the basis of that report, the speaking order was passed. So there was no error on the part of the authority in passing the speaking order.
No, that's all right,
Yeah.
but they have taken a plea on the basis of this annexer 8 that they are continuously working.
Well, that's in
And-
writ petition.
and-
Well, in fact, my
and
lord,
this-
in fact, in writ petition number 4110 of 2023, my lord, the hearing, my lord, the hearing file also, I have to say, my lord, that the working certificate that was submitted by the headmaster of that school confirms that she has been working from 2001.
That all right.
Only in respect of this
respect of-
petitioner.
Yes.
And the other petitioner, my lord, there is no, this aspect is not a part of their petition, my lord.
Maybe, but this letter also includes their name.
Letter doesn't disclose any name, my lord. It simply says 5 unpaid now.
7,
My lord,
annexer 7.
page 36.
Yes.
Page 35.
35.
35.
Hmm. Like your lordship will see, Hemanto Borua, irregular in his duties since 2014. Puravi Bhattakur presently working irregularly. Shabina Expen presently working. fact, my lord, the speaking order, your lordship will see. In fact, the speaking order also has indicated one fact, my lord. There were contradictory report from the deputy commissioner, my lord.
Who is
The-
responsible for the same?
Page 38 in the third paragraph from the bottom, my lord. In this regard, the office of the deputy commissioner had furnished an inquiry report dated 18/5/2020 and 12/11/2021. The earlier report of deputy commissioner dated 11/5/2000 and recent reports are as mentioned above are contradictory.
Now, my
And
submission.
this, my lord, 2021 report perhaps is the basis of page 36, my lord. Page 35 and 36.
So, yeah,
My lord, may I be permitted to reply to my learned friend, my lord? My lord, to cut very short, my lord, I beg to draw my lordship's attention to the, my lord, minutes of the cabinet, my lord. My lord, the cabinet minutes starts at page 35, my lord, and I straight away, my lord, can peruse clause 4 at page 36, my lord. And my lord, I also beg to draw my lordship's attention, my lord, that this is a cabinet memorandum dated, my lord, 28/7/2019, my lord. Now, my lord, here in para 4 says that but some teachers who were also appointed in excess over the vacancies at that point of time were left from getting the fixed pay, and these 45 such teachers in Nagaon district and 7 teachers in Sunitpur district are still working but not getting any fixed pay since their appointment. Considering the entire matter, the department took these steps and called for, my lord, may kindly appreciate, call for a working status report from the Deputy Commissioner and the Inspector of Schools, Nagaon and Sunitpur district. Accordingly, the Deputy Commissioner and the Inspector of Schools had submitted a detailed report stating that these teachers in Nagaon and Sunitpur districts are working without receiving any fixed pay since joining, my lord. The Inspector of Schools, Nagaon, had also identified the equal number of vacant posts for adjustment. So, my lord, this paragraph is clear and explicit, my lord, that we were working till 2019. Now, what the cabinet has done, my lord, they have annexed the list as annexure 1, that who are the teachers, my lord, are entitled and eligible for the fixed pay. My lord, can kindly turn to page 39, my lord. Page 39, my lord, in page 4.
Mr. Bhuya, already you have shown it.
My lord, that's why, my lord.
Serial number 38, 39, 40.
Exactly, my lord. These are the teachers.
41.
My lord, my lord. These are the teachers, my lord, they are working and they are very
So,
speaking order.
Mr. Yeah, you see.
My lord.
Because he was conducting subsequent.
Subsequently, my lord. That is correct, my lord. That is correct.
Yeah. And in this paragraph number,
Now, my lord, in the speaking order, my lord, they have said that after this, my lord, cabinet memorandum, they have again conducted the inquiry and wherein, my lord, in these 3 reports.
so Mr. Bhuya, you see in the report dated 27/1/2021.
My lord.
The Deputy Commissioner Nagaon has stated that petitioner, no, one city, Poroma Gora,
My lord.
Sahabuddin Ahmed, Purobi Borthakur, and Sabina Yasmin, they are presently working.
My lord.
And in respect of Hemanto Bora, it is stated that irregular in his duties since 2014.
That is the contradiction, my lord. That is the contradiction. Why my respectful submission before my lord is that the cabinet took up the inquiry report of the deputy commissioner and the inspector of school of the in the year.
Subsequent report.
No, my lord, that's why, my lord, that's why my submission before my lordship is that these all inquiries, all reports are redundant, my lord. They cannot be taken into account. How the authority or the executive, my lord, can, after the cabinet take a decision, my lord, can again reopen the inquiry, my lord. Because the cabinet, my lord, by basing on the inquiry of the very deputy commissioner and the inspector of schools, my lord, has decided to give us the at par benefit, my lord, to these 45 numbers of teachers. Now, my lord, out of that 45, 37 has been extended the benefit
and eight numbers, my lord, had been, my lord, has been segregated from that benefited list of 45 numbers, my lord, which is a violation of, my lord, Article 14, my lord. We have been segregated without any reason. Now thereafter, my lord, when we came before them that we should be also given the extended the same benefit, then only, my lord, they have decided to conduct a fresh inquiry and all this purported report have come up. Now, my lord, in this report, they have said that the deputy commissioner has also, my lord, submitted contradictory report. Now, basing on those contradictory report, my lord, this speaking order has been passed, my lord, which is automatically, my lord, vitiates the entire exercise of this speaking order, my lord. So therefore, my lord, my respectful submission before my lordship is that as we are equally situated, my lord, these 45 numbers of teachers, my lord, we have been found equally working. Now, my lord, what did they do any, my lord, after this cabinet, my lord, memorandum? They have not done any inquiry for these 37 numbers of teachers, my lord. Why, my lord, why we were, my lord, not given the benefit, that is not available on record, my lord. When we approach,
In respect
then,
of
my lord,
37, my lord, I have the records, my lord. Entire records are there.
no, that is
Their
correct, my lord,
attendance
but-
records, everything are there.
But my lord, my respectful submission, my lord, is that once the cabinet memorandum and the cabinet decision is there, my lord, only the cabinet has the power to recall, review or modify that decision, my lord, and they can thereafter could have taken a fresh inquiry, my lord. But overriding the cabinet decision, suo motu by the executive, my lord, is a interference with the, my lord, usurping the power of the cabinet, my lord.
So on the other day, I have asked you to furnish some judgments.
Yes, my lord. Yes, my lord,
You got it.
I have prepared a bundle of judgment, my lord. 3 judgment I have got, my lord, wherein it is very clear the power of the separation of power and the cabinet power has been also elaborately discussed, my lord. I will furnish it by tomorrow, my lord.
Okay.
My lord. So, my lord, therefore, my lord, and in the affidavit also, my lord, in the affidavit filed by the Director of Secondary Education, in my case also, the plea which I have taken that regarding the separation of the power, they have not denied, my lord. The director has not denied. So therefore, it is an admitted case, and this speaking order, my lord, is also beyond power. This speaking order, my lord, they have issued beyond power, and which is amounts to ultra virus, my lord. So therefore, my lordship is maybe pleased to examine that, my lord, whether after this cabinet decision, this speaking order they could have passed or not. That's my humble submission, my lord. And
Mark also the inquiry report.
My lord, 2 have marked, my lord. 2 I got it, my lord.
And the other one.
Other one, my lord,
Not
I'm trying to find out, my lord. From
Okay.
there are 3 records, my lord, from the. I'll give you.
Sir, here we have not a product. WPC number 75 of 2023.
935.
935 of 20. And the photo of it is the 411.
Secondary.
Department. Every board respondent number 5. And Mr. Portable for respondent number. What was it for respondent number? 6.
The finance department, my lord.
But you
Finance, main. Exclusively within the domain of the secretary. Because the inquiry has been. Without him, we will not get anything.
His role will come, my lord. Wazir Khazana. The entitlement.
No, Lordship will kindly only one submission. Lordship will kindly appreciate one aspect of the matter. In the entire inquiry process, finance has no role. It is absolutely within the domain. Yes. So therefore, at the end of the day, if Lordship holds that this will go, or if it remains, my lord, then we are bound to. That's what. We are only a formal party.
Yeah.
Very honest.
I have also flag marked, my lord, the working certificate that was given by their respective headmasters, my lord, in the hearing.
We'll see. But the subsequent letter of the deputy commissioner,
Well,
where he has stated.
if your lordship will
some of
kindly
them
see,
earlier-
this speaking order is not only based on the deputy commissioner report, but it says, my lord, the finding is based on the records that is produced in the hearing, my lord. If this lordship is say, records indicate that they were not continuously serving irregular and absent without any record of authorization for a long time. So this is the record, my lord, which is a basis for the speaking order, my lord. And this is the record, my lord, pursuant to the hearing that was conducted, my lord, which is the letters of the hearing letters, which are annexed in the writ petition.
Now, you tell me, why this order was passed, if your order was passed?
When these representations were submitted to ensure that whether these people are working or not, this inquiry has been directed, my lord. The hearing was directed.
See, the cabinet has taken a decision on the basis.
In
of
fact, my lord, for
inquiry.
37 also this was done. In fact, for 37 also this was done. Everyone's attendance registers were verified, and thereafter the notification of 2020 was issued.
No, after considering all aspects, the cabinet has taken a conscious decision. And after the decision of the cabinet, what is the occasion for further inquiry?
No, cabinet has taken, my lord, the reason for taking the decision in respect of 45 is to maintain a parity with 244. That was the reason for cabinet's decision, my lord. Now to implement the cabinet decision in true spirit, because somebody who is not in job, my lord, cabinet would never approve that. However, my lord, when this implementation of this cabinet decision was done by the government in 2020, for 37 teachers, my lord, same exercise was done. Everyone's
Maybe,
working status.
You may have done the exercise, but the question is, whether you have the power
Yes, my
to
lord.
override the decision
No,
of the cabinet.
no, cabinet decision, my lord, to give a parity to these 45 teachers. That was the intent of the cabinet decision, my lord. Now to give the benefit, the authorities always will have a right to examine whether the persons are entitled to get the benefit, the decision of the cabinet or not.
Once the cabinet has held that they are entitled.
Entitled.
Then
No, cabinet has not said, my lord, they are entitled. Cabinet says, as the 244 teachers are getting, and therefore the other set of teachers should also get the fixed pay. Like 15,500. That was fixed for these 244 teachers.
argument conclusive, judge later.
Mild. Obliged, my lord. Lord, I will furnish those by tomorrow.
By tomorrow.
Mild.
Oh.
Obliged.
Any submission required from court?
No.
Bro, one more submission your lordship will take into note of. My lord, to lordship will also see the decision making process, my lord, by the authorities while passing this speaking order.
Okay, we will see.
Second wife, first wife. The lordship quoted on maintainability of,
I'm the first guy.
I am the first wife, my lord. Question has come, my lord, your lordship was observed that it is disputed fact. My learned friend has made a submission.
Yeah.
Then your lordship fixed it for to address on maintainability of the case, madam.
Yeah.
Maintainability point. So my case is, my lord, here, whether your lordship will take it to the key. Now, what I am saying, my whole time will allow not, my lord, this is what I am saying. Madam.
How much time you will take?
I don't know, but it all depends on him also. My question, my lord, I am just by short, I am saying, my lord, if possible, your lordship will, otherwise, any day affliction. First wife, my lord, marriage, what they are saying, my lord, simple is they have cancelled the Kabin Nama. Kabin Nama cancelled. Now, your lordship is aware, Kabin Nama when comes? After marriage, Kabin Nama. At the time of marriage, Kabin Nama comes. So marriage is different thing, Kabin Nama is different thing, my lord. Kabin Nama comes only when marriage takes place. If marriage is there, I am the legally wife. Second question, my lord, they filed a case before the court below. I have filed a case, 498 A, my lord. In that case, court also observed that, and he also admitted that Kabin Nama cancelled, but there, because in that case, some conviction was there, my lord. And because of that, there was an agreement. In the agreement, both of them decided to live together as usual, as husband and wife. This is the case, my lord. Now, my lord, if your lordship, if you go to the civil court, nature, my lord, a wife, my lord, I think age, not a single child, and she is alone, my lord, and nobody is there. The present lady, second one, is having the children. They are also employed, to my information. They are earning also, my lord. So this fact, prima facie, what I find, my lord, she is the wife of that man, my lord, prima facie, because by the agreement also he has agreed, my lord. That also we have annexed, my lord. So this is simple, my lord, I'm saying. If you go further, my lord, naturally, we need some more time, my lord. This is the- So this is basic prima facie, if you are satisfied that my lord, I am the wife. Because just I am saying, my lord, one paragraph, my lord, I'm saying to your lordship, my lord. That page 49. Yes. In this case, but actually, page 38, there is a my lord, the of the conviction was made under section 406 with 3 months irregular RI, my lord. And against that, because of that, my lord, this agreement, page 49. Your lordship will find, I take your lordship to Barnacular portion next. Page Barnacular, my lord, page 51. Chukti Patra. And your lordship will find the signature of both the persons, my lord, husband and wife. Present petitioner as well as that husband, my lord. দ্বিতীয় পক্ষ রোমান সহিংস স্বামী your lordship will find চুক্তিমতো স্বামী স্ত্রী হয় your lordship kindly see চুক্তিপত্রনামা কার্য হওয়া যেহেতু কে পক্ষ প্রথম পক্ষ আর দ্বিতীয় পক্ষ সম্পর্ক স্বামী স্ত্রী হয় প্রথম পক্ষ দ্বিতীয় লোক বিবাহ হওয়া প্রথম পক্ষ দ্বিতীয় পক্ষ বিবাহ নগাঁও জেলার ফৌজদারি আদালত গোচৰ দায়েৰ কৰিছিল বৰ্তমান দুয়ো পক্ষৰ মাজত নিম্ন সত্য সাপেক্ষে এক আপোচ মীমাংসা হৈছে আৰু উক্ত আপোচ মীমাংসা মতো সবাই পক্ষ মানে প্ৰতিষ্ঠিত এই চুক্তিপত্ৰ সম্পাদন কৰে So what more is required, my lord, to say that she is not the wife, my lord? This is my, I'm simply saying.
Whether this is a registered document,
My lord?
whether this is a registered document.
Not
It is here, my lord. I say.
Agreement
Oh,
registered when.
Oh, register মানে চুক্তিপত্র, my lord, but the case is here, my lord, your lordship, page 38. Just because of that, because he is an employee, my lord, he was employee of the government provincial high school. So there is a page 38, your lordship. Considering the facts and circumstances of the case and in the interest of justice, accused is sentenced with 3 months aggregate imprisonment and fine of rupees 1,000 under section 406 IPC and in default so and so so and so on. So because of this matter, he had to enter this agreement. So what more is required, matter for the purpose of pension matter? That is, I am only on that point. And this is his signature is available here. So I think your lordship can enter into merit also, my lord. If your lordship, I can overcome that point subject to your lordship that here, my lord.
Yes, Mr. Kokon, what is your stand?
My lord, regarding that maintainability aspect, my lord, I have already furnished the Supreme Court's judgment, my lord, that Rima Agarwal, only 2 paragraphs, my lord. That will clarify the, my lord, scenario, whether it is maintainable or not. This judgment, my lord, rendered by a criminal court, whether it is applicable to the present proceeding, my lord. Rima Agarwal versus Anupam and others, 2004, 3 SCC 199. My lord, paragraph 11 and 18. 2004, volume 3 SCC 199.
2004, 3 SCC
199.
199.
Paragraph 9, paragraph 11, million. The question as to who would be covered by expressing husband for attracting section 498A. That judgment is regarding 498A and 406, million. Thus, present problems etymologically in terms of definitions of husband and marriage as given in various law lexicons and dictionaries, the existence of a valid marriage may appear to be a sine qua non for applying a penal provision.
in so and so case, a woman claimed maintenance under section 125 of the CRPC. This court applied the provision of the Marriage Act and pointed out that same was a law which held the field after 1955. When it was enacted and section 5 lays down that for a lawful marriage, the necessary condition that neither party should have a spouse living at the time of the marriage is essential. And marriage in contravention of this condition therefore is null and void. The concept of marriage, it is important, Miller. The last 4 lines. The concept of marriage to constitute the relationship of husband and wife may require strict interpretation where claims for civil rights, right to property, etc. Milord, right to pension is a right to property, Milord, as per Constitution bench judgment, Milord. I'll place that judgment later. Where claims for civil rights, right to property, etc. may follow or flow, and a liberal approach and different perception cannot be an anemia when the question of curbing a social evil is concerned. Now, kindly turn to paragraph 18. That will be suffice, Milord, regarding this 498A. Page 209, paragraph 18. The concept of dowry is intermittently linked with a marriage, and the provisions of the Dowry Act apply in relation to marriages. If the legality of the marriage itself is an issue, further legalistic problems do arise. If the validity of the marriage itself is under legal scrutiny, the demand of dowry in respect of an invalid marriage would be legally not recognizable. Even then, next page. It is important, Milord. Even then, the purpose for which section 498A and 304B IPC and section 113B of the Indian Evidence Act 1872 were introduced cannot be lost sight of. Legislation enacted with some policy to curb and alleviate some public evil rampant in society and effectuate a definite public purpose or benefit positively requires to be interpreted with a certain element of realism too, and not merely pedantically or hyper-technically. The obvious objective was to prevent harassment to a woman who enters into a marital relationship with a person and later on becomes a victim of the greed for money. Can a person who enters in a marital arrangement be allowed to take shelter behind a smoke screen to contend that since there was no valid marriage, the question of dowry does not arise? Such legalistic niceties would destroy the purpose of the provisions. Such hair-splitting legalistic approach would encourage harassment to a woman of her demand of money. The nomenclature dowry does not have any magic charm written over it. It is just a label given to demand of money in relation to marital relationship. The legislative intent is clear from the fact that it is not only the husband but also his relations who are covered by section 498A. The legislature has taken care of children born from invalid marriages. Section 16 of the Marriage Act deals with legitimacy of children of void and voidable marriages. Can it be said that the legislature, which was conscious of the social stigma attached to children of void and voidable marriages, closed its eyes to the plight of a woman who unknowingly or unconscious of the legal consequences entered into the marital relationship? If such restricted meaning is given, it would not further the legislative intent. On the contrary, it would be against the concern shown by the legislature for avoiding harassment to a woman of her demand of money in relation to marriages. The first exception to section 494 has also some relevance. According to it, the offense of bigamy will not apply to any person whose marriage with such husband or wife has been declared void by a court of competent jurisdiction. This is important, Milord. This 7-8 lines, Milord. It would be appropriate to construe the expression husband to cover a person who enters into marital relationship and under the color of such proclaimed or feigned status of husband subjects the woman concerned to cruelty or coerces her in any manner or for any of the purposes enumerated in the relevant provisions section 304B, 498A. Whatever be the legitimacy of the marriage itself, for the limited purpose of section 498A and 304B IPC, such an interpretation known and recognized as purposive construction has to come into play in a case of this nature. The absence of a definition of husband in 498A, section 498A, Miller, the absence of definition of husband to specifically include such persons who contract marriages ostensibly and cohabit with such women in the purported exercise of their role and status as husband is no ground to exclude them from the purview of section 304B or 498A IPC, viewed in the context of the very object and aim of the legislations introducing those provisions. So, my lord, the 498A, the definition of husband, is not strictly interpreted, my lord, and it is not relevant to the right of property. My lord, for right of property, that means right to pension. My lord, as per constitution based judgment, my lord, it should be strictly, my lord, interpreted. So, my lord, as per 498A, which has been, my lord, annexed as Annexer A by a criminal code, that, my lord, interpretation, my lord, regarding husband, the word husband, my lord, it's a liberal interpretation, my lord. So it is not applicable in the instant matter, particularly regarding right to pension. So, my lord, from that perspective alone, my lord, this writ petition is not maintainable. Since, my lord, a criminal code declares, my lord, that the petitioner and late Lutfur Hussain, my husband, my lord, I am the only wife, not second wife, my lord. So, my lord, my husband and the writ petitioner relation as husband and wife, as declared by criminal code, cannot be relevant in the instant matter. So, from that perspective alone, my lord, it is not maintainable. And second one, my learned senior friend has pointed out that agreement, the wording, my lord, of terms and conditions, that will also clarify that they are not husband and wife. May I take your lordship straight to page 49? My lord, it will be much clearer in vernacular, my lord. It's page 52, clause 3. May I read in Assamese, my lord? Page 52, clause 3.
Yeah.
প্ৰথম পক্ষ আৰু দ্বিতীয় পক্ষ উভয়ে বৰ্তমান স্বামী স্ত্ৰী হিচাপে বসবাস কৰিব। বৰ্তমান যিহেতুকে দ্বিতীয় পক্ষৰ বাসস্থানৰ অসুবিধা হোৱাৰ বাবে প্ৰথম পক্ষৰ পিতৃগৃহতে দুয়ো থাকিব আৰু অতি শীঘ্ৰেই দ্বিতীয় পক্ষই প্ৰথম পক্ষৰ নিজ ঘৰ সাজি, ইট ইজ ইম্পৰ্টেণ্ট, my lord, সম্পূৰ্ণ স্ত্ৰীৰ সন্মান ও মৰ্যাদা প্ৰদান ক্ৰমে নিজ গৃহলৈ লৈ যাব। Till then, she has not been given the status of wife, my lord. After this agreement, the husband would take the writ petitioner to his home and that status would be given. Till then, বৰ্তমান স্বামী স্ত্ৰী হিচাপে বসবাস কৰিব। So, my lord, this agreement is signed possibly in 2004. Exact date is 14/9/2004. And marriage is of 1999 as per the writ petitioner's contention. And furthermore, my lord, this is not a registered agreement. So it does not have any validity in the eyes of law. My lord, from these two perspectives, my lord, writ petition is not maintainable. They cannot produce opposite party could not produce the marriage certificate the Kabin Nama, nothing, my lord. Only the judgment of a criminal court, my lord. And as per section 25 of the Act, my lord, only the civil court has got that jurisdiction to declare husband and wife. It will be a legal chaos if a criminal court declares. It will be a legal chaos, my lord, if a criminal court declares the validity of a marriage, my lord, declaring someone husband and someone wife, my lord. So, my lord, regarding maintainability aspect, my lord, this is my submission, my lord. After that, my lord, I'll again submit. দাদা আপনার যদি মেরিটত যায়
My lord, whole question, my lord, criminal court, for the purpose of 498A, decided that she is legally married wife, right? That has remained unchallenged. It was not challenged at all, my lord. So after the, my lord, the judgment, when the conviction and sentence was pronounced, then because in order to save his service, my lord, he entered into agreement. They're not denying this, my lord, this signature, etc. And first they are saying, my learned friend has said page 52. I am reading 51. First, my line, my lord, this চুক্তি যেহেতু এক নম্বর পক্ষ আর দ্বিতীয় পক্ষ সম্পর্ক স্বামী স্ত্রী হয়, সম্পর্ক স্বামী স্ত্রী হয়, this signature they are not denying it is not signature, my lord. They are not saying so. And then these conditions have come. So I think this is enough, my lord, that remain unchallenged, that judgment, and for the purpose of pension, my lord. So for maintainability, I think it is there, and purpose of pension also, she is entitled as per Supreme Court judgment.
This agreement was entered into by the parties after the conviction recorded by the trial court.
By the trial court.
That
my lord,
means
Then he has
the
recognized,
of the-
initially he has recognized me, earlier, my lord, he was, because he ousted me. That was the case, my lord, 498A, my lord. then. So thereafter, when he found that, my lord, he was convicted and ultimately because he is a government employee, my lord. So he had to ultimately admit that, yes, she is my wife.
may I point out one
And then,
vital,
my lord, it will come there.
one vital.
So ultimately, he admitted only because earlier also, my lord, 498A case was there because of that, because he was not taking her, my lord, care. So that's why maintenance, and otherwise she have, my lord, 125 or 498A. The torture was there, she was ousted from that house. She was living with her parents' house, fine. And when this, it was, my lord, recorded, sentence was recorded, then only he had awakened and has said that, yes, you are my wife, I am now taking you, and we shall now live together as husband and wife. What more is required, my lord? If you say that, my lord, it is his signature. If he say it is not signature, certainly it will go to FSL, my lord, if they say. If they admitted that his signature only because of contents, I don't think, my lord, your lordship will, that way, you'll also have to believe that, yes, it is their own statement and one agreement.
So, totally going by this agreement, it is difficult to hold that you were husband and wife. You were husband and wife.
Yes. So ultimately, so husband and wife. Husband is husband and wife, he admitted, my lord. Maybe after that here, my lord.
No, it appears that since this was entered into only after the pronouncement of the judgment of
This,
conviction.
no, marriage was there because I was wife, I filed the case, and because the consequence of the order, my lord, he has entered into that. It is a continuous process. It is not that, my lord, suddenly he has entered into the agreement. It is not that. With reference to that case, he has come, my lord. And case is a continuous process, my lord. That is cases of 2001, CR case, my lord. 2001 case. So it is continuing, my lord. It is not that suddenly he made an agreement. It is not there, the case. This in terms of because of the judgment, which was pronounced later. But the case is continuing since 2001. And marriage was 99. So it is not that suddenly this agreement was taken, my lord.
My lord, the conviction is not under 498A.
406.
Page 38. 406. only.
Yes, sir. Yeah, I'm correcting, my lord. 406, my conviction 406.
Page 38.
But court found that, my lord, she is the wife. Your lordship, kindly just have a look, my lord. Yes. Page. Your lordship will find. Yes.
33. Don't wait.
Yes. Yes, madam. Page 33, my lord.
Don't.
33. Bottom. Read a person guilty under section 490A, the victim must be legally married wife. From the entirety of the evidence, I am of the considered opinion that the prosecution has been able to prove that the victim is the legally married wife of the accused.
Okay. So Fukan, anything to submit on merit?
Milord, on merit, Milord, since Milord, it's regarding hearing regarding that maintainability aspect, Milord. So, Milord, this is my submission, Milord. Since Milord, a criminal court cannot, Milord, observe or opine regarding validity of marriage, and if we, Milord, refer this Rima Agarwal case of the Supreme Court, then it is for limited purpose of that section 498A. My learned senior friend just pointed out page 33 regarding the bottom 5 lines. I am the considered opinion that prosecution has been able to prove that victim is legally married wife of accused Lutful Hussain. It is as regards the first opening line. To hold a person guilty under section 498A, oblique 406. 406 is not relevant, Milord. 498A. Only for that purpose, Milord. For that dowry aspect, Milord. Since to curbing a social evil, as per the Supreme Court's judgment in Rima Agarwal, Milord, for only for that limited purpose, Milord, that husband and wife relation, Milord, this criminal court has got that opinion, Milord. And ultimately, he has not been convicted under 498. And this agreement, long after 5 years, till then, Milord, no husband-wife relationship exists.
After 5 years, man?
99 marriage and 2004, that agreement, that unregistered agreement, where it has been, Milord, stated that from now onwards, we will live together as husband and wife. And respondent number 9, Milord, the marriage was held in 2000, Milord. Months prior to this agreement.
No, that is from the date of agreement is not date of marriage one. But it's just page 32 also bottom, just for 1 minute. Of 30 seconds it will take, madam. Page 32 bottom, madam. After your lordship, page 32 bottom, madam. Earlier I said page 33, madam, now 32 bottom. After perusing the evidence of all the PWs, it appears that the accused Lutful Hussain has married the company Lutful Nasa on 12/12/99 as per Islamic Sharia and Nikah.
Sir Chaudhary,
My lord.
question is whether this observation is binding upon
But it remains unchallenged, my lord. I am saying from the prima facie, my lord. I am not saying that, my lord, only for the prima facie for the purpose of pension, my lord. Whether I am wife or not. If your lordship finds that I am wife, then merit will come, whether my right to property, whether it is applicable, that is another aspect, my lord. But prima facie, I find that yes, she is wife, it remains unchallenged till today, my lord. And in pursuant to that, agreement also taken place, my lord. That's why I am saying, my lord, prima facie, I am the wife of that year. The agreement has, my lord, strengthened the position of that year, my lord. Substantiated the proof, my lord. Agreement. Signature has not, they have not denied that it is not the signature, my lord.
Okay. Alright, sir, is there a Chaudhary learned? That's it, sir.
And who's
Sir, you have other number?
9.
9.
Nine. So other.
I put 12/5.
They report with 5. That's all. Talukdar for respondent number one. Respondent number one. Argument concluded.
Most of us.
Item 30.
Thank you.
This matter pertains to a disciplinary proceeding of whereby the petitioner was imposed with a penalty of compulsory retirement. This, yes, in the last occasion, they had taken time to go through the record. I had furnished a copy of the inquiry proceeding. If your lordship recollects, the day before yesterday, when the matter was called up, he wanted some time to go through it. So if your lordship permits, but perhaps may I pray this matter may be taken up tomorrow because it won't take much time. This is a small matter, disciplinary proceeding, because the proceeding is of 6 pages. I will not trouble your lordship for a very detailed and lengthy argument. I'll just point out certain.
Okay, tomorrow.
Tomorrow? In that case, tomorrow.
Tomorrow, lot of matters have been fixed under the column admission.
But I have checked, my lord, there are many serious matters. So I'll try my luck tomorrow at 2 o'clock. If your lordship takes up tomorrow at 2 o'clock, then.
Yes, sir.
Yes, your lord.
Okay. As agreed by Lord and Professor of the party, with the subject the matter. I think you would not be able to complete the argument in 5 minutes. 5 minutes, please.
Well, matter of, very urgent in the sense that the students are suffering.
That's right, but on Tuesday, then.
Madam?
Tuesday.
Monday or Wednesday, madam. Monday, Tuesday, I have some problem. Monday or Wednesday. Either next Monday or Wednesday.
Monday and Wednesday, whatever matter, they are miscellaneous day. And hearing may be tough.
Tuesday.
Yeah, Tuesday, this Tuesday, I have some problem, madam. It's coming Tuesday.
Thursday.
Thursday, I can do. Thursday, I let him.
Anyway, madam, let it be fixed on when we will try.
সোমবারও কৰিব পাৰে, no problem. মই সোমবাৰে আছো।
সোমবাৰ কৰিব পাৰি। Or let it on Monday, we'll try.
Monday.
Monday, because a bit urgent, because session is now will start.
That's agreed by Lord and with the Professor of the matter on Monday. Monday at 2 PM then.
Yes, sir. Obliged.
Obliged.
In this matter, my lord, a date may be fixed, my lord, short date. 11th, my lord, if it is possible.
11th, there is some difficulty, lordship. Can it be on, lordship, any day after 19th, lordship?
19.
Yes, after 19th, lordship.
That's agreed by Lord and with the party.
No, any day after 19th, lordship. 25th.
23rd.
23rd. Obliged.
11 করে 11